Fine. Okay, thank you. Okay, well, good morning. It's 10 o'clock. This inquiry is open. My name is Mr. Bale. I'm the planning inspector appointed to conduct this inquiry and to determine the appeal by Maxo Homes. Can everybody hear what I'm saying? And is the live stream recording picking up what I'm saying? Thank you. Please, can everybody make sure that their mobile phones are turned off or switched to silent for the duration of the event, please? Are we expecting any fire drills this morning? No. The exits look like they are sideways out the building or behind you, the way you came in. Are there any further instructions about evacuation?
So only that the congregation point is in Luxford Field, and for those that don't know the area, it's the green area just up the steps in front of the centre. Okay,
thank you. So this appeal relates to the failure of Wealden District Council to validate and determine an application for planning permission. That application was made under Section 73 of the Town and Country Planning Act, and it sought planning permission for the conversion of a care home to form 8 flats, together with the construction of 9 new dwellings and associated works at Wealdhall Residential Home in Wadhurst, without complying with various conditions attached to a previous grant of planning permission. Now, in shorthand, such an application is often referred to as an application to vary conditions. That's not strictly what happens. If the appeal is successful, what would actually happen in law would be that a new planning permission would be created alongside the existing one. So we sort of use the term variation of conditions in shorthand, but the actual proposal is as I just described. But this is important because in considering such a proposal, I can only consider the question of which conditions should be applied to that. And I won't be revisiting, as part of my decision, the whole principle of the development. That said, I am aware of the history. Presumably, gentlemen, you are local residents to the scheme. So I'm aware of the history. I'm aware that there's been some controversial things in your words, and I've read all of the evidence, so I sort of know what's happened in the background. But I just want to set out now that I can't go back to the start through the process of this application and this appeal. So, the matters for discussion at this inquiry then are quite narrow ones, and that's why we're scheduled to sit for one day, and I do intend to get through proceedings today. More on that and the procedure later on. Before we go any further, though, can I take the names of the people who intend to speak today? If you speak, then I'll record your name in my decision letter. If you want me to record any professional qualifications against your names, then please do so. Mr. Charles, I saw that you had provided a list of people, so I've got it electronically. It's fine. So I've got the qualifications against that. But if anybody else wants any qualifications recorded against their name in my decision letter, then please state them when you introduce yourself. So let's start with the appellant, please. Who is representing the appellant today?
Forgot. Apologies. I'm a solicitor, Sebastian Charles, APCR Legal LLP, instructed by Maxo Homes. Sir, if required, we have 2 witnesses of fact, Mr. Lackabeer here, who's a director of Maxo Home Limited. We also have Mr. Chandan on standby. My understanding is that the point about whether the works occurred is now conceded, and so we're not intending to call him unless we need to. He's on site, he's half an hour away, we can bring him in if required. And then in the roundtable discussions, Richard Murray of Murray Planning Associates and Matt Mercer of Tetra Tech.
Who appears for the council, please?
Good morning. Thank you. My name is Miss Victoria Hutton, MS, Ms. Hutton, Hutton. On my left, I have Andrew French, who is Sustainable Drainage Advisor to East Sussex County Council, the lead local flood authority. So if I send through letters after names to pins, would that be appropriate? Okay. Yes, it can, yes. Next to him, Sir Scott Carey, Planning Assistant Team Leader at Wealden District Council. Next to him is Stacey Robbins, Planning and Environmental Services Lead at Wealden District Council. And then next to Mr. Robbins is Joanna Denton, Senior Enforcement Officer. I don't know exactly who will be speaking, sir, but that's our team.
Thank you. So I'll now take the names of anyone else who knows that they would like to say something today. You don't have to commit at this stage. If something occurs to you and you'd like to join in later, that's fine. I can take your name then. But if you know that you would like to say something, it would help me if you say who you are now. Yes. So, Mr. Hello, is it? Michael Hello. Okay, yes, so you're from Clearview. Yeah, okay, understood.
What's your name, Michael? Hello. Thank you.
Thank you. Is anybody here from the press? The event's obviously being filmed and recorded today. Are you, at the back of the room, monitoring that live stream to make sure that it stays active? Okay, thank you. Because I understand that some people were intending to watch. And if we can just make sure that that keeps running, and if there's any problems, do intervene and say that we need to pause. Thank you. So for the information of those not directly involved, I held a case management conference with the main parties on the 21st of March 2025. That was a virtual meeting via Microsoft Teams. It involved the appellant and the council. That was a procedural meeting, sorry. Just to clarify what happened on that day, it was a procedural meeting. We discussed matters about who would be appearing today, the appeal procedure, the likely duration, and the likely main issues. Importantly, we didn't discuss anything to do with the merits of the case, any detailed legal arguments, or the evidence itself. I would say we did have a brief discussion about the validity of the appeal, just to make sure that we sort of got up and running today, and so that I could understand the council's position on all of that and determine the procedure that I was going to follow for the appeal today. So that happened, but we didn't get into the sort of nitty-gritty of the evidence in any way. And given that the application was never validated, we also discussed the procedure that had to be followed to make sure that there had been some consultation and publicity of the proposal, which has now happened, and I've received your responses in due course. There was a full record of the CMC that I believe is on the council's website. Thank you. So in terms of notification then, I've seen the letters of notification of the appeal and the inquiry. I've seen letters of the appeal and the inquiry. I've seen evidence that the site notice has been posted. I know that there was early concern raised by the parish council and neighbouring residents that the application information was not available, but I think that's all been addressed, and I think that all of the information in connection with this appeal is now publicly available. Is that fair? to say? Yeah. Yeah. Thank you. So I think everything is in order, publicity and notification-wise. Does anybody have any comments to make?
It might be worthwhile recording that we have now a member of the parish council who has joined as well.
And your name, sir?
Hi, I'm Councillor Phil Moore. Apologies for my tardiness. It was a late change because the previous councillor couldn't attend.
Okay, so Councillor who, sorry?
Philip Moore.
Philip with two L's?
Just one.
And how are you spelling Moore?
M-O-O-R-E.
Thank you. And you're representing Wadhurst Parish Council?
Yes. Thank you.
So, as mentioned at the start, the application subject to this appeal was never validated by the council. That's because the council's primary position was and is that there is no extant planning permission. So that is, the original planning permission that this proposal depends upon has expired. My first task then is to decide whether that is the case, and that's not a decision I make today, that's a decision I'll make in my appeal decision later on. But my first task is to decide whether that is the case. And there's two relevant issues as I see them in connection with that. The first is the question of whether a material commencement was made within the time limit for commencement. And in this case, it must be shown that that occurred on or before the 5th of June 2025. So that's the first point. And the second point is whether there were any conditions that might have prevented such a commencement being lawful. And there are two conditions, I think, numbers 6 and 8, that the council believed to be true conditions precedent, as we call them. There's condition 7 as well. I'm not entirely certain of the council's position on condition 7, but we'll carry on for the moment, and that will come out. Certainly conditions 6 and 8. And details relevant to those conditions have not been approved. I think that's uncontroversial.
Check. I don't think you mean 6 and 8. I think you mean 5, 6 and 7. 8 is about floodlighting.
Is that the statement of common ground?
Correct, yeah.
So if we return to the original planning permission,
Yep.
because the condition 1 in the statement of common ground has been deleted, which is the commencement condition.
I understand.
So we've bumped up a number.
That's fine. We've referred them all the way through as 5, 6 and 7, but I think we know which conditions we're talking about.
Okay, well, I'm referring to 6, 7 and 8 of the
Surface
permission.
water management and maintenance.
Yes.
Foul.
Correct. So details relevant to those conditions have not been approved, and if the council is correct, then that could have prevented a lawful commencement having been made, and the permission would have lapsed. So if I'm with the council on the validity matter, I'll just set out now that that will be the end of my decision, and I won't go any further. I cannot proceed to consider the question of the conditions under section 73, as there would be no extant planning permission. On the validity matter, the onus is on the appellant to prove their case to the standard of the balance of probabilities. That said, it's also an established principle that their version of events should be accepted if there is no contrary evidence, and provided that their evidence is sufficiently precise and unambiguous. So that's the principle within which I'm going to be making that decision. Before I go any further, and without straying into any formal conditions, I understand that the council now accepts that a material commencement did take place on or before the 5th of June 2025, That being my first issue.
So yeah, it's not disputing that it did. The council's not giving a positive case that it did. It's not disputing the appellant's case.
Okay. So just a moment. So what I'm interested in at this stage is to know what the parish council and the neighbouring residents' position is on this matter. And I don't necessarily want you to go into submissions. I want to know if you intend to challenge the appellant's version of events.
Yes, from the perspective that this was clearly a key matter around the expiry of the planning consent. And it was a matter, as you're aware, that I submitted a Freedom of Information Act request to the council to establish more about. There was an interesting point around this, which was the date of the expiry of the consent. And in the papers that you have seen that I've supplied to you, the council were talking about the 6th of June, not the 5th. And this, from my perspective, was a misunderstanding about the date of expiry. It's relevant because a lot of the correspondence that was provided to me, pursuant to that, referred to the 6th. And it included the assumption of liability for, I can't recall what it is, CIL, I think, which then referred to the start of work happening on the 6th. So I am raising this question because I don't feel that there is sufficient persuasive evidence that the work happened, to the extent that any work happened, on the 5th. The information provided to us suggested that the 6th is a more likely date, if something did happen, that it happened.
Thank you. So this issue is still sort of, I'm going to hear some more about this later on, I think.
Yes, I mean, just to be clear, we know it's the 5th. The photograph that we've submitted, a date stamped the 5th. We knew the deadline was the 5th before the deadline arrived, and our stat deck says the 5th, and the photographs say the 5th. So I am happy for the parish council and the public to raise the issue, but I think the sole question is, do they have any evidence that the works shown in those photographs didn't occur on the 5th? Because I think they're challenging the principle, which is absolutely fine, but I mean, they can't have any evidence, in my understanding. If they do have any evidence, of course, we'd be delighted to hear it, but I'm not sure from what they're saying. They are saying they went to the site on the 5th and there were no workmen there.
So I think the position is that you don't have any contrary evidence as such. It's that there are these matters of uncertainty within the evidence.
The only evidence that we have, because we couldn't access the site, is that the CIL statement of assumption of liability
So that's
is
what it comes
dated
to,
and
yeah.
says the 6th, not
Yeah.
the 5th. But that is the only evidence. Yes.
Yeah, so that's what I thought was the case. So in terms of how we proceed this morning, Mr. Here, or is it Mr. Lack? Sorry, Mr. Here. Mr. Here, did Mr. Here complete the assumption of liability form?
I don't know who completed the assumption of liability form, but the problem is you can't backdate it.
No,
So
well,
it will say whatever date it
I'm not
says when
taking
it
notes
goes
at the
in.
moment. I'm
Yes.
just trying to establish a few things in my mind.
Yeah.
Mr. Here, did you complete the assumption of liability? Okay, right, okay. So I'm just trying to decide who and how I need to hear from people, really.
Yeah, so in my submissions, the date on the seal is not relevant to when the works actually occurred. We have, out of abundance of caution, client took photographs because we knew it might be challenged. Those have been supplied, date stamped with the correct date, although initially with the wrong date, the date of transmission.
So I can hear,
There are two stat decks that have been.
yes, I understand that. And I can hear later about why the dates are the dates, and you can give me an explanation about that. The question is whether it's necessary for anybody to speak to that.
Yes,
on oath.
just my question back to the public and the parish council. Did they attend the site on the 5th and could see that
Well, I think we've heard that
taking
they
place?
couldn't.
Yeah, because you can't see it from outside the site. So my view would be there is no contrary evidence. We're very happy to call evidence. We have stat decks prepared. We have witnesses available if necessary. It just seems a waste of time and costs on your correct analysis of the balance. But I'm completely in your hands, sir. We're not sensitive about the issue. We've done everything we could do to resolve it.
Because another option before me, as I put in the note last week, is that we're in the inquiry procedure, so even if we don't call formal witnesses to give evidence, we could administer the oath on one or more, or everybody in this room, if necessary, to speak to these points.
We'd much rather you put the issue completely to bed, sir, than had any lingering doubt about it. And as we have our witness here, we're very happy to do that as required.
Ms Hutton, do you have a view on the most expedient way to proceed?
So no, I don't, because the council is not disputing
Doesn't
it.
dispute the point.
So it's a matter for you, and I don't know whether you yourself have questions. So that might mean you want the witness in front of you under oath. You will have seen, our cost response, which gave the council's initial concerns about conflicting evidence.
Sorry, sir, I just want to stop you for one moment. Mr. Murray's been checking. The SIL notice does state the commencement date as the 5th of June.
That was my first submission, and I was asked to change that part.
So, I think... Yeah, sorry, Ms Hutton.
So it really just depends on whether you have questions. I mean, we've provided the council's position in our cost response with the conflicting evidence. If you have questions, then it's a matter for you, sir.
My feeling is that if Mr Murray in due course is able to explain how the date situation arose, my gut feeling is that I probably don't need to hear that on oath. What I don't want to do is start a discussion and then have to backtrack and do it later, because that's a waste of everybody's time. Mr Davis, do you think, once you've heard Mr Murray's explanation, I'm not going to say you're going to agree with it, but do you suspect that that might be the end of the matter?
Because there can be no absolute certainty, there's evidence indicative on both sides of this. I think it's your decision entirely. So I think I speak for my neighbours as well on this point, that we can't be categoric about what did or didn't happen on a specific day. So that, I think we're happy to leave it at that.
My feeling is that...
I would like to respond, sir, that we are categoric.
Well, yes, okay, you are categoric, and your statutory declarations make those points. My gut feeling is that we can proceed without administering the oath. I think. That's what I'm going to do. Okay. I can't see any... If somebody says something later, I can't see any procedural reason why I can't change that. Do you agree? Okay, fine. Okay, so the procedure then, carrying on from where I was on the first point about validity, in the event that I'm with the appellant and I find that the permission is extant, then I need to go on to consider the question of the conditions to which permission should be granted. And there's outstanding dispute about those, and they are conditions 6, 7, and 8. And I think all of the others are now agreed. So that discussion will take place on a without prejudice basis to the council's primary position. That said, I think that there will be things that we talk about in that discussion that might be material to my decision on the validity point later on. So whilst I've split the agenda up into various topics, I don't think that they're not discrete in my mind. They're to guide the discussion today. They're not discrete topics. They won't necessarily be discrete topics in my decision either. So this inquiry has two main purposes. First is to enable me to put all of the information I need to make my decision. And the second is to give all of those who wish to speak on relevant issues the opportunity to do so. An inquiry is a formal process. Please bear in mind that you shouldn't speak unless I invite you to do so. That said, a large part of all of today's discussion is going to take place as what we might call a roundtable discussion. That I shall chair based on an agreed agenda, and there's a few copies of my agenda floating around. For clarity, though, I'm just going to outline the procedure because it's slightly different to a hearing because it is, strictly speaking, an inquiry. And that means that before we go anywhere, I'm going to invite opening statements, first from the appellant and then from the council. And then we'll move into the round table discussions on the basis of my agenda. There will be no formal cross-examination of anybody, though, so any points please make through me, and if there's a question that needs to be put, then I will do that myself. We'll start with some questions about the legal principles and commencement of development and conditions precedent. And then we'll go on and discuss the disputed conditions and some of the other matters. After that, I will undertake a site visit. Now, we'll see how timings go today. I'm quietly optimistic that sometime early afternoon we might be able to do the site visit and then potentially come back here for some closing submissions after that. How long have we got this room for? Which is what? What's the end of the day? 6 or 6:30. Okay, well, we won't go beyond that. That's going a bit extreme. We've got Thursday morning possibly reserved for closing submissions virtually. I'll be on the train on Wednesday morning, so it won't be happening then.
I have Thursday earmarked for closing submissions, and so there is quite a lot that might come up today, so I think it might be quite challenging to do closing submissions straight away.
Okay, we'll see where we are.
However,
Yeah, Ms. Sutton.
See where we are, sir. So apologies, that's not in my diary.
Okay, fine.
however, sir, I'm going to make a suggestion to you that would be very helpful to resume after the site visit. And the reason for that, sir, is we've received a draft cost submission from the council's team. One of the reasons they put forward for not considering the additional material and the alternative schemes that we submitted yesterday is because they claim never to have visited the site drainage area, which we refer to as off-site, and it is true that it is outside the red line, but it is the existing drainage system for the nursing home. We consider it highly material that the council is arguing that drainage goes to the heart of the permission, whilst at the same time apparently never having inspected the drainage that we're discussing. Being fair to the council, we think they ought to have the opportunity to view the existing drainage and be given the opportunity to withdraw their case, because I think on site it looks entirely different to how it may appear from the plans. Now, I know the council has visited the site because I participated in a video call when they were there, but it may be that they didn't ever go and look at the existing drainage system. But that is extremely material to the issues being discussed, because the whole point here is that the drainage system are very minor tweaks to an existing system that can be seen and has until recently operated on the site, but the council are saying they can't possibly comment on that because they've never looked at it. So, being fair to them, I think once they've looked at it, they ought to have the opportunity to reconsider their case.
Okay, well, we'll come back to what's actually on site in due course. Ms. Hutton.
So, yeah, well, I think what the primary issue we need to decide, and so we'll get into this, is what is the scheme the appellant is applying for? Because if this is a reference to the positioning of a large drainage basin outside of the red line boundary, then it doesn't matter, actually, that no one visited. That's another reason why it can't be dealt with, because the other impacts haven't been considered. The first issue is you simply don't have jurisdiction.
Well, and it won't surprise you that we'll come to that in a moment.
Exactly that. So we need, as a primary matter today, we need to know what is the appellant applying for, because it seemed clear in the final comments that there was a movement away from what had been applied for. All of that was superseded by the new technical note, which included this drainage basin. There was then an email yesterday, which the council simply hasn't had time to look at in detail. The LLFA hasn't had time to look at all. So we, as a primary issue, we need to be dealing with what is the scheme we're discussing.
Okay. Thank you. Well, I'll come back to those issues later on. The point is, for the moment, at some point after the site visit, I'll hear closing submissions, and that might be later on today, or it might be virtually on another day.
Sorry, just on that, could one option might be in writing?
It might.
Or might, but
I'm not. It's possible. It's possible. But it's not necessarily ideal.
okay.
We'll see. But it is an option. In terms of diary management, are you not available on Thursday?
So I'm going to have a chat to my clerks and see if I can move things around.
Okay. And we might not get there. I mean, and it depends on what it is you want to say as well, because, of course, the council will go first in closings,
Yeah.
and so you might be able to do that today, and Mr. Charles on another day. We can be flexible to a point.
Yes, and so there will be a cost application from the council, which has been provided in draft in writing to the appellant yesterday. That will be updated to reflect what goes on today, so that would obviously need to be factored in.
And we might be able to, I'd be more comfortable dealing with costs entirely in writing from both sides than I would closing submissions, but we'll see. The gist of all of this, anyway, is that I'm going to do my best to get through as much of the business today as possible. It's a slightly flexible event. We will go to site at a convenient time. We may or may not come back here afterwards, and we'll see how that goes. Does anybody from the local community have any time constraints on their diary today?
No,
okay.
None of us.
Thank you, that's helpful. At the site visit, are there any health or safety issues to be aware of? Could you use the microphone, sorry?
There are very specific arrangements around access to the land in which the sewage treatment, the existing infrastructure that treats sewage on the land that the care home owns, but it's really only restricted to maintenance, to maintaining the existing infrastructure. So, yeah, I mean, we can open the gate today for that, but It is through a private track, which I own. Sorry.
And you're happy for the inspector to view the whole site and to look at the... Thank you.
I'll need to be accompanied by a representative of the appellant and the council whilst we're on your land. Is that okay? Okay. Thank you. All right. When we get to the site visit, it's just an opportunity for me to have a look at things. I'm not going to be having a discussion on site about things. You'll be able to point out things that we've talked about, but we're not going to have submissions and detailed discussion about things.
You might need to agree some plans to take on the site visit, and I would suggest the title documents would be one document to take with, as well as whichever.
Well, perhaps you can have a think about that later on, about what you'd like to show me while we're there, and you can have a discussion over a break. Does anybody, well, just while we're on timings, sorry, I'll take breaks as convenient throughout the day. We'll try not to sit for more than about an hour and a half at a time. But if anybody needs to take a comfort break, or if you think that there's a need for a break for some other reason, don't sit there suffering. Please say, can we stop? That's fine, and if it's appropriate, we will do so. Does anybody have any questions or concerns about the procedure?
So it's quite warm in here. Could we have
Indeed.
an adjudication about jackets?
Yes, well, I was thinking it wasn't as warm as I expected, but perhaps I'm just sort of in more of a
I was
zone.
very happy in my
You
shirt
are-
sleeves, and then you turned up with your jacket on, so I've put mine on. And
Well,
now
this
I'm feeling
morning,
a bit toasty.
this morning I thought I might just walk into the inquiry room without a jacket on at all. So you are free to take off your jackets. You may take off your ties. I might do the same later on.
I wasn't going to go as far as ties, so.
I'm happy for you to go as far as ties. I really am. The temperature is going to climb, I think, through the day. So let's be mindful of that and make ourselves comfortable. It's your contributions rather than your appearance that I'm more interested in. Right. Final procedural point is about costs. We've heard that there's an application for costs. There's going to be an application for costs from both sides, and we will decide how to deal with that later on. Just a reminder to everybody that I also have the power to initiate an award of costs if I consider that unreasonable behaviour has occurred. And if I were to do that, that would follow a written procedure after the appeal had been determined. Right, so to the first point of discussion, we're still, actually, before we go to opening submissions, I would just like to speak about the proposal. So, Mr. Charles, looking past the validity point, what is the proposal that you think I should be considering?
So we have a menu of options for
Indeed.
you, with a lead case, a first alternative, which is the large basin, which we included in our final comments. Appended to the council's final comments was a further LFA consultation response dealing with our technical notes, dated 29th of June. So we submitted that to the council in advance of the further deadline comments date. The council consulted the LFA on it and received a consultation response, which they didn't share with us, but included it in their final comments.
Which the council says is their statement of case rather than their
Whatever.
consultation response.
It's a further consultation response from the LFFA or part of their case, I don't know, but they had it on the 30th of June and didn't share it with us. If they had shared it with us on the 30th of June, we could have included comment on that in our final comments, but we hadn't received it by then.
So your menu of alternatives, Mr. Charles.
Yeah, so menu one
Your
is-
primary case is what?
Our primary case is that the 2025 guidance does not need to be applied to this scheme, and therefore we can rest on the scheme as submitted with the original condition discharge condition with minor amendments. that we carried forward into the 2025 section 73.
So that is the plans and documents that were originally submitted with the application,
Correct?
and the documents and plans that are listed in the conditions in the Statement of Common Ground.
However, we have somewhat trimmed them because they are a little bit confusing because several iterations were submitted at that stage.
You've trimmed what?
The original submissions, the list of plans, I think we have shortened a little bit because
Right.
you only need the final versions, you don't need each iteration that was submitted.
So what is the case?
The end result of the original submission. And our case on that revolves around the extent to which the 2025 guidance applies to them, and I will make submissions to you about the terms of the 2025 guidance.
Yes, okay.
The LFA's position is
But
that
the plans that you want me to consider, are they, you
round
say
one
you've
is
trimmed?
as originally submitted.
Yes, so you say you've trimmed them. So
Yep.
is the list of documents, I think there's 6 in the
Yep.
condition,
Yep.
in the Statement of Common Ground. Is that the proposal?
No, our updated list of conditions is a shortened list of those documents.
And have I seen that list?
No, not yet. We'll table that when we get to the discussion about
Okay.
conditions.
Can you table it now so that we know
Yes.
what we're dealing with?
Okay. Ben, do you want to pass those around? So we have a list of conditions for each of the options that we're putting forward.
Okay, this is quite a fat list. So what have I got here?
So
Oh,
this
so
is
option 1, so this is what you said.
yeah.
Okay. So option 1 is,
I'm calling it the original scheme. Didn't take into account the 2025 changes in the guidance because it predated the 2025 guidance, which didn't apply when it was submitted.
so this list here, seven documents, is that the same as the list in the Statement of Common Ground?
I don't think it is quite so. Give me 1 second.
That's changed to simplify that.
Yep.
Now, that was obviously submitted as a pack showing the previous
Yep.
submissions, and they've all been now collectively put into this text.
Yep. Yeah, so it's changed because when they were originally submitted, they were submitted sequentially. There is now a summary or an explanation of the final position that is the accumulation of those plans they submitted.
Sorry, I couldn't catch what you said there.
Sorry. So the option 1 condition that we propose is to bring in the technical note DRN R1 rather than referring to RPC 0302A. Is that correct?
Yeah, so that's the surface water management plan, which was.
Right,
the-
sorry,
the
yeah.
council's concluded in every single one when really it should be just.
Yes, right, sorry, so let me just explain it in detail. So in the Statement of Common Ground, the council's...
So one person at a time, please. Sorry.
Yeah, so referring to the Statement of Common Ground, the council's condition 5, Roman 1, is the surface water management plan. We delete that from our condition because the surface water management plan should be under condition 6, which is the management plan condition, not the scheme details condition.
I see. So, yes, so you've changed the... So you've deleted something from condition 5.
Correct.
And you've
And then the technical note and the drainage.
and you've added something else.
Yeah, the technical note and the drainage plan bring together all of the previous iterations that were made. So they're not different, but they bring them all into one place and make them consistent.
So is that a reference to the Roman 1 drainage technical note? Because there's two, there's one at Roman 1, there's one at Roman 4. Just if we could have the dates of all the documents, because I'm afraid at a loss.
That was originally submitted, all these were originally submitted to the
Yeah,
application.
so these all form part of the original 73 or the original plan?
When this
Yeah.
document at condition 5 Roman 1,
Yeah,
when did that get submitted?
as part of the section 73.
No, it's the reference is June 2026. It's 29th.
Yes.
That's the one that's recently been.
It's the
Yeah, the
29th
29th of June, yeah.
The 29th of June.
Yes. That's on this
Right.
first one. Your technical note.
So that's not the original submission.
It contains the original submission documents. The response that had come back from the local flood authority seemed to be very confused. Naturally, this has been born out of the confusion that previous submissions had not been validated and looked at and passed on. So there was a chain of events where there was ongoing negotiation between our drainage team and the council, and the first submission just collectively submitted all that previous information, but there appeared to be confusion at the start in their first response. So this first drainage technical note, Roman 1,
It's the 29th of June
yeah,
note.
and consolidates all that into a more readable package and also explains the situation. But the documents are still contained within it.
So that's the 75-page document. And the other things there, Roman 2 through to 7, they were originally submitted with the Section 73 application. Apart from the drainage plan Rev 1, which number? Roman 7. Okay. So this isn't a list of documents submitted. Sorry, I'm asking some silly questions here, I'm sure, in your mind, but I'm just trying to make sure I understand what's going on here. So you made the Section 73 application. There are documents with that, and I've got those, and they were submitted with the appeal at the outset. Then Condition 5, Roman 1 and Roman 7 are new documents.
Responding to the first LFA consultation response, but we only received that consultation response after the appeal had been submitted. So at the CMC, you directed the council to consult, because until that point, no consultation
Yes.
with the LFA had happened. In response to the LFA's first round of consultation, which I will categorise as, this all looks a bit complicated, we don't quite understand what you're doing, can you explain? We then explained in detail in the 29th of June. It's not changes, but it's bringing everything in together to make it clear what the end result of the prior submissions were, because we can agree it was a bit confusing because things had been submitted sequentially without necessarily making clear what was superseded and what was supplemental. But that is all explained in the 29th of June note.
Does the 29th of June note also include the new drainage basin?
Yes, as an additional option. And that's the large drainage basin.
So the plan listed there is a mixture of the original proposal. Because you've included the note at Roman 1, that list of plans is a mixture of the original proposal and the new proposal.
Correct, but if you were to approve the original proposal on the basis that the new guidance wasn't complied with, the new guidance requires the basin to achieve the attenuated flow rate that if you don't apply the regs, we don't need. So if you take the 29th of June note and omit the basin, it works for securing our lead case of a drainage scheme that meets the pre-25 guidance situation and can be approved on that basis.
Yeah, and I'll talk about that later.
And then if you do require the 25 guidance to be complied with, our first round was to add the off-site basin, and that's option 2. So the condition for option 2 is the same as option 1, but with the off-site basin added. And I'll call that the large basin. And it requires a little bit of explanation, and we're delighted Mr. French is here. Our understanding was that the only issue with the originally proposed scheme was that it didn't comply with the 25 guidance, and it depends on a way you measure the flow rates. And this is what gives rise to the difference that we included in our email yesterday between the 8.3 litres per second and the 4.7 litres per second. The 24 pre-guidance solution is 8.3 litres a second, and the 26 large basin is 4.7 litres per second,
Right.
which was the target that the LFA wanted us to achieve with the scheme.
Okay, I haven't written that down for the moment. I'm going to
I
come back
have
to that
explained it all in my
later on.
openings when we get
So option 2 is
the big basin.
Is the large basin that appeared on the 29th of June
Correct.
in the document that is also listed in option 1,
Correct.
condition 5, Roman 1.
Correct.
Okay. Then option 3, is that what appeared while I was on the train yesterday?
Correct. That's a small basin to address the point raised by the LFA and the council in their final comments that was sufficiently different from what was there before that it needed planning permission. So there's no suggestion the big basin doesn't work, my understanding. The only issue is that it would need planning permission, or in the council's submission it would need planning permission. We think the big basin is marginal as to whether it needs planning permission or not. We think that it would be granted planning permission if it were applied for, but it is, as a matter of fact, bigger than the existing basin and is somewhat over-engineered. In order to demonstrate to the LFA we could overcome their concerns about flow rates comprehensively, it is a more engineered solution than is necessary. As soon as we received the comments after the date for final submission about the big basin needing planning, we said, do we need a basin as big as that to hit the flow rate? The answer is no, we don't. So our third proposal is the small basin. The council may still say that they consider it needs planning permission, but I'm sure they will agree that it is less likely to need planning permission than the big basin. And our submission is either that it doesn't need planning permission or it will be granted planning permission.
Now, you have to forgive me, although I don't know, given when it arrived, I don't know that you do. I haven't really studied yesterday's documents in any way, nor has the council.
No, you said you
that.
didn't want any more submissions in writing, so we will explain this all to you verbally, sir, if you require. But the only reason we were in need of putting that solution in is because the LFFA consultation of the 30th of June we didn't receive in time to include it in our final comments. So by not providing it to us until the exchange of further comments, which happened the next week, we were unable to include comment on it in our final comments. So that is why it is late.
Does the option 3 basin, so there's a smaller, there is another pond in that, it's a smaller one.
The pond is unchanged. We're just talking about the basin. There is an existing...
Sorry, the basin.
Yeah.
Yeah. Is that outside the red
It is,
edge as well?
but it's on the site of the existing basin, which when you go to site, sir, you will see there is a basin there already. We have not surveyed the existing basin to be able to say for certain we can reuse the existing basin and hit the flow rate. So the small basin is the basin most like the existing basin that definitely meets the flow rate requirements. And
The large basin, option 2, and the small basin, option 3, are they in the same place?
Exactly, sir. And they're in the place of the existing basin,
Okay.
and they have been engineered to meet the LFFA requirements.
Okay, fine. That's all right. Okay. Let me just catch up with some notes a moment. Hold on a moment.
And the basin,
Just
sir,
a moment.
Yeah.
Yeah.
The basin is on the appellant's land, but outside the red line.
Mm-hmm.
There are no works outside of the appellant's ownership. So the pipes and the pond, no works proposed there, owned by the appellant's neighbour.
Right, and we'll come to discussion about that in due course. I just wanted to try and
I
establish
think it's very wide, sir, because it's quite complicated.
what you were doing. Yeah, Mr. Moore, Councillor Moore.
There we go. This is feeling a little bit shambolic. We haven't seen any of these documents. We're not drainage engineers. How are we meant to judge any of this? I mean, we're taking it on spec that, you know, it feels odd that somebody who's claiming they got something done in time is presenting documents on the day with 4 options, a bit of a pick and mix. I mean, is this where we are? I mean, if they need planning permission, they should go and get planning permission. This is an appeal of an existing thing. I mean, this is, to me, I mean, I'm a layman, but I am a parish councillor. This seems incredibly shambolic. I mean, we've got 4 options here. How are we meant to adjudicate these?
Well, that's part of what I'm trying to get to the bottom of, and I'll have to make a decision on what I can and can't take into account in due course. So I'm just, for the moment, just
No,
trying to
I appreciate
establish
that, sir,
situation.
but respectfully, this is feeling a little bit beyond the pale, to be honest. I mean, I don't know what you think.
Mr. Hellu.
Frankly, we're half an hour into this and I'm more confused than I was going into it. But just the references to the basin, small basin, large basin, the pond, all of that work is happening where exactly? I mean, where did, I mean...
Well, we'll come on to that in due course, I think, if you don't mind holding fire on that thought. Ms. Hutton.
So I don't know where to start. Planning appeal is not a buffet, it's not a negotiation, it's not a horse trade. The appellant applied for what it applied for. It has no right to amend. If it wants to amend its proposal, it should make an application for a particular proposal, for that to then be responded to by the council and by interested parties. That's important because, one, there are issues over jurisdiction when it comes to stepping outside of the operative part of the planning consent. And I can address you on that, sir. That's been pointed out to the appellant. There's no doubt why this shambles is happening now. It's also important in relation to consultation, because there are proposed to be works on land not owned by the appellant, where the landowner not even aware of what's going on. For absolute clarity, sir, the LLFA, and therefore the District Council, is not content that any of these proposals meets either current guidance or the previous guidance. There's further key missing information in all of these proposals. So when the appellant seeks to put words in the council's mouth about what is or what isn't agreed, we'll come on to that. The LLFA will explain the position. In terms of it, the council being criticised for not providing what is said to be a consultation response, so you have our response on that. It's not a consultation response. It's part of our final comments document. The LLFA are appearing here on behalf of the District Council. So turning to the options, and the council has not reviewed in detail the note that came through yesterday. Option 1, condition 5 has 3 drainage designs within it. So the original condition applied for, you will have seen the LLFA raised concerns that there were conflicting drainage designs and calculations. So I'm instructed that the Roman 3 drainage statement, Ardent document, conflicts with the proposed drainage details plans at Roman 6 and Roman 7.
So we're in condition 5.
Yeah, we're in condition 5, option 1.
Option 1, condition 5.
So there were already, on the application forms, there were already conflicting drainage designs. So the council's position is you could never have granted what's been applied for anyway, because there were conflicting proposals and evidence. The addition of Roman 1, the drainage technical note, is a third drainage design, because the first thing you read in the drainage note when you look at Part 3 surface water drainage proposals is that the original submissions are superseded for historical reference only, and then it lists the principal updates to the design, and we see the SUDS interception feature, rainwater harvesting, and some additional comments on greenfield runoff. Again, so even if you were to select, and again, it's not for you, sir, to select options, but if the appellant were to plump for option 1, it could not be granted, because there are 3 different designs. So the appellant has to be clear what is the design being applied for that we can all speak to. We can't have numerous different options floating around before you today, with everyone trying to address different documents, different evidence, not being absolutely clear. We need to be absolutely clear where are things going, what is the evidence that supports those plans, so that everyone in the room, not just the council, are clear on what's going on.
Okay. I think the introduction of Roman 1 into condition 5 creates some very significant uncertainty about what your primary proposal is. Now, I understand that your primary proposal, as arguably it should be, is the one that was made with the application when it was first submitted. And then you've responded to various iterations, and that's led you to option 2, the large basin, option 3, the small basin, which was yesterday, and I'm not sure what option 4 on site means. But no doubt you'll explain that in due course. Is it fair to say that your primary proposal is option 1, subject to potential inconsistency? The others have arisen in response as essentially, you're saying, well, if the council's view is this, then we can deal with it through option 2 and option 3. So you're demonstrating, seeking to demonstrate that there are ways available to deal with the council's concerns. Is it fair to accept it in those terms?
So just to respond to the 2 comments that have already been made, we are extremely sympathetic to the parish council and the local residents' position, because when this application was made, the council expunged it from their website and pretended that it had never been made. And this is the root cause of the problem. In the ordinary way, they would have consulted the LFA at that stage on an application. Whatever their view was about validity, consultation should have happened at that stage. In the ordinary way, there would have been a bit of toing and froing, and the scheme would have been agreed with the LFFA. This is what happens all of the time. In order, we say, to support its case about non-implementation or about heart of the matter, the council declined to do the consultation that it was required to do. This was discussed at length at the CMC, and you wisely, sir, directed that the council should do consultation at that point. But at that point, we'd already lodged the appeal, as that was the only way to bring the council to the table to do the consultation it should have done on the application. We may not, through this appeal process, be prejudiced and excluded from the process of seeking to agree the scheme. The scheme would have been agreed as part of the application, but for the council corrupting the process and not consulting on our application in order to bolster its weak argument that there was no application to consider. That has continued.
I understand your position on all of
sorry,
that.
just let me finish. Yeah. It has continued by the withholding of the LFA response. Through the Statement of Common Ground procedure, we asked repeatedly to have technical discussions with the council's technical advisor, and that was denied. So the council are coming to you today to say those consultations that we didn't do when we were supposed to, and those discussions that we've refused to let you have, are now the reason that we win the case, and our original case theory of there is nothing here, we win it by the back door by excluding you the possibility of having a scheme on the table to consider, and that is not appropriate to happen. And if that is the council's case, that is full costs against the council for their conduct, because it all arises from
I'm not
lack
going to
of
get into that
consultation.
now. I need to get on with the discussion.
Yes, sir, but let me continue. Our position is, sir, we're fully content to work with all parties to agree the solution here. This is not that difficult. It is a mild refresh of an existing drainage scheme on a scheme that has a 50% reduction in foul flows and a 90% reduction in surface water flows. It should not be that difficult to come up with a permission that can be granted.
Mr. Charles, thank you.
But just also to finish, the parish council, I believe, want this development to happen, to remove the derelict building.
We're straying off. We're straying off. What is your proposal, which is mine?
I'll come back to my... So we've got 1 and 2, which are the 2 drainage basins.
Yes.
We have also proposed a condition that enables you, sir, if you consider either one of those does need planning permission, to grant a permission that is deferred until planning permission is secured for either one of those schemes. So if you decide that, and without conceding our own case, you may decide that the big basin does need planning permission because it's so different from the existing basin, but you might decide that the small basin doesn't require planning permission. But if you require that both of them need planning permission and you wish to see a basin in order to make the scheme acceptable, you can impose a condition requiring that to be the subject of a separate planning application. That will all get agreed and the scheme will be agreed on the basis of that. And we will hold fire on the development until that's granted. We're very happy to do that. We don't see a problem. We don't see any basis that that planning permission wouldn't be granted.
So is that what overarching is about?
No, overarching is later. I'll finish once I've done
no,
3.
let's not go there.
Yeah.
Okay, thank
4 is our alternative, because this is a site with multiple options. Drainage is so not a problem. The drainage issues can be resolved in many different ways. We have so many options available. A short discussion with the LFA would sort this out in no time at all. We're very glad Mr. French is here. I will also be suggesting that he and Mr. Murray sit in a room, sorry, Mr. Mercer, sit in a room, because we're absolutely confident in the ordinary way it would be agreed. If the LFA had been consulted on the application, it would have been agreed before the appeal was submitted. We were denied that opportunity. But it's really not that difficult. This is a very easy scheme with significant reductions in the issues that the LFA is attempting to address around foul flows and flow rate for surface water. It's really, really easy. It doesn't demand all of this drama to resolve.
Okay.
So what we've done for option 4 to address the concern about off-site works is a wholly on-site solution, which works to the 4.7 flow rate and can be accommodated wholly within the red line. And we have a scheme and the drawings all worked up to demonstrate that. So
And those drawings that are listed in option 4, have I got those?
those were provided yesterday.
Right. Right, okay.
And then the 5th sweeper is you could just decide to impose a condition requiring the drainage to be looked at afresh, as if we hadn't got there, but just with a new trigger to do it after commencement of development. And hopefully, in that case, it will be consulted upon and resolved in the ordinary way. So that's our sort of sweeper. We'd like to walk out with a permission we can build tomorrow because Mr. Here has been very patient. We're here a year later on a scheme that is urgent with the parish council looking at a derelict building, security risk. We've had one fire already. It's
Okay,
cost a
so
lot of money.
let me stop you there. So I
There's no
think
issue here.
what it seems to me, and you can call it what you will, the overarching option here, a new permission with a new trigger, that is an option available.
Yeah.
Notwithstanding all of the validity argument that I need to deal with first,
Yep.
but if I get past that and into the situation where I decide the permission is extant and the Section 73 application is therefore valid, an option is to grant a permission with a new trigger to agree the drainage scheme. And that's why I'm going to be candid and I'm going to suggest that the way to proceed today, I think, is to deal with your primary proposal, which is the application as made, that everybody's seen and everybody knows what they're dealing with, and decide, if I need to, whether that scheme is acceptable or not. If it is, you get your permission you can walk away with tomorrow. And if you don't, then there is an alternative permission with a new trigger that requires you to go and agree the scheme. And in your view, there are at least 3 options available to you to achieve that. But we can't have a discussion today about those 3 alternative schemes. I don't think I could follow it, quite frankly, and I don't think it's fair on any of the parties because they don't know what they're dealing with.
I will take you through them in my opening because I've explained it.
Mm-hmm.
I agree there is a degree of complexity, but that is entirely not our fault and it's caused by the failure to consult. I would say don't be too hasty to rule out the small basin option because I think when you see it on site, it becomes kind of obvious that that's the direction of travel. It is possible that there is actually another option, which is to just use the existing, but we would need to do more survey work to get to the bottom of that to prove the flow rate to the satisfaction of the LFA, which we're not in a position to do on the timescale that we're on. But I would just, we're very happy to work with everybody to find a solution.
I think this is the way we need to go. And I think what I would like you to do in an adjournment at some point is just to clarify for me what your primary proposal is, because I don't think that this list that you've got in option 1 is correct, because there's too many schemes.
Mr. Mercer will
in
explain
it.
that to you to the best of his abilities.
So I could just do with a list, and I think the council could do with a list of documents about what you're expecting to have approved. So perhaps you could deal with that shortly. Let's hear your opening statement. I said 5 to 10 minutes. I'm hoping I'm going to hear both opening statements before 11:30, and then we'll take a break.
Just say thank you for indicating the way forward. Just on overarching, the council will, obviously this is again new to the council, will consider that. Just to flag that the wording of that is not necessarily agreed. Given the particular concerns over timing, the council may well be saying to you, so this should be an enforcement type condition, i.e. within 6 months, X, Y, Z should happen.
Okay.
That sort of condition.
Okay. We'll come to that. Yeah.
These opening comments are prepared by Sebastian Charles, solicitor.
Mr. Charles, have you got a copy for me?
These opening comments are prepared by Sebastian Charles, solicitor, LLB, LARTPI, HCR Law, formerly Aardvark Planning Law, on behalf of Maxo Homes Limited, the appellant. There are 4 simple matters to be resolved in this appeal. Question 1, did works adequate to implement the permission take place on the 5th of June? I'm hoping, sir, that we've got to the bottom of that and I don't need to spend any more time on it, and we'll respond to the council's submissions about costs in due course. Do drainage or any other conditions go to the heart of the permission in this case? I'll come back to that in a moment, but I think we're agreed that drainage is the only issue and there are no other issues. Are the details contained in the Section 73 application acceptable or not? We've had to do further work to address the LFFA comments attached to the Council's final comments. It's extremely unfortunate that the Council did not disclose the further LFA comments immediately on receipt, the 30th of June, because if it had, we would have had the opportunity to address those comments in our final submission. That opportunity was denied. We address those comments now. There are 4 simple solutions to the issues raised by the LLFA. The appellants put forward 4 alternatives and 1 sweeper. Firstly, approve the original scheme as submitted in June 2025. Apart from a single issue relating to hydro brake flow control devices in the management plan, no technical evidence has been put forward at any time to show that did not comply with the applicable guidance at the time, and the evidence of the appellant is that it does. Our submission is that this may be approved by the inspector, either on the basis that the Section 73 is not new development to which the guidance applies, as opposed when compared with the development in the 2024 permission. The proposal is unchanged, the scheme of development is the same, and there is nothing new. We do accept that Section 73 gives rise to a new permission, but we don't agree that that means new development. In the alternative, the guidance includes express provisions that they are to be applied flexibly. We say in the circumstances of this Section 73, simply retrospectively regularise the breach of condition with no scheme changes, that would be appropriate. Also, taking into account that by undertaking the development results in reduced, not increased flows. If the guidance were to be applied in a way such that the development were to be frustrated, forcing a resumption of the prior lawful use using the existing system, this would result in a resumption of greater flows, entirely defeating the purpose of the guidance, and this would be perverse. In the alternative, the 2025 guidance can be complied with. The appellant's first solution was the basin proposed in the 29th of June technical note. We note the Council's concerns that this may require planning permission. Whilst not necessarily agreed, those concerns are noted, and a condition is proposed along the following lines, and this is my form of condition, that we make a planning application for it to be resumed later. We've also put in a written note expressing the view that, in our opinion, planning permission would be likely to be granted, so we see no policy or practical objection to it. The alternative solution is for a smaller drainage basin, which is also located off-site. Details were circulated yesterday, and our engineer is present to explain them today. It achieves the same runoff rate. It requires less works, and in our submission could, and in our planning consultants' experience frequently are, undertaken without a grant of planning permission on the basis the works are de minimis, or in the alternative, it can be subject to the condition described above if you decide so that it does require planning permission. Either basin would require a small addition to the management plan, which is also sent yesterday and referred to in our condition. Out of abundance of caution, the appellant has also developed a further alternative solution which can be implemented wholly on-site within the current application red line. Details were circulated yesterday, and our engineer is present to explain them today. The appellant's planning consultant has reviewed all 3 options and conclude they are acceptable in planning terms and all perform to the required guidance. The relative performance in terms of the objectives of the guidance are set out below. Existing flow rate 59.4 litres per second. The development without drainage upgrades 59.7 litres per second. Slight increase. 2024, so the original scheme, sir, reduces the flow rate to 8.3 litres per second. That's pre-25 guidance. Applying the 25 guidance, either the large basin or the small basin or the on-site all deliver the 4.7 litres per second aspiration of the lead local flood authority. We submit, sir, this is a material consideration. The appellant's preferred approach would be for the inspector to approve the scheme as submitted in June 2025. The evaluation of the scheme has only been required to address the change in guidance since then, which is the basis of the LFA's comments. So far as we can ascertain, it didn't and still doesn't find any defect with the original scheme at the time of submission, or they've asked for further information which has been provided. If Mr. French wants to correct me on that, very happy to deal with it. We did ask repeatedly through the Statement of Common Ground process what exactly it was the council considered wasn't agreed. You'll see the Statement of Common Ground just says it's not agreed. We don't know why. But for the single issue of the hydrobrake flow control device, which we've dealt with. The net result of the regulation changes are to make provision for intersection features to allow the first 5 millimetres of rainfall to drain to ground rather than via positive discharge, and this creates the requirement for the basin, which was not previously required, and for the on-site water butts, which are not controversial. These intersection features are easy to accommodate and can be added in the 3 alternative ways described above, raising no new or controversial technical issues. In the final alternative, the appellant would be willing to accept a wide-reaching overall condition. This is our sweeper, as we've described. Question: has the council behaved reasonably? See below in relation to costs. At this point, the council does not agree the appellant's technical details, but we remain unclear why not. It may be that it does not accept the information about foul drainage flows and thinks there is still going to be an increase, or it identifies some flaw in the drainage proposal not previously identified. If that remains the case, at the hearing, the council's technical evidence will be scrutinised as to its reasonableness. Our submission at this point is that the council's refusal to accept the technical details is unreasonable. It may be that the council doesn't intend to produce technical evidence, but to simply hide behind the LFA. I'm slightly unclear of the LFA's role as a consultee and now witness for the council, but we didn't know they were going to turn up. If the council position is that it's happy if the LFA is happy, it would be helpful if it would confirm that and then get out of the way and let us deal direct with the LFA in the usual way. Unfortunately, the council has unreasonably manipulated the consultation process. It failed to consult the LFA when it should have done at the application stage, meaning the LFA's comments could not be addressed before the appeal was lodged. It then withheld the LFA's final comments until after the deadline for the appellant's final comments, and this was also unreasonable. We understand the council may seek to argue under Wheatcroft that a response to those comments ought not to be submitted. In our submission, it's not appropriate for the council to be running a Wheatcroft argument opposing late changes to the scheme in these circumstances. If the council had consulted the LFA on the application when it was submitted, which it should have done, their concerns and all the issues could have been addressed in the application before the appeal was lodged. The only reason they were not was because the council chose, unreasonably in our submission, not to consult until directed to do so by the inspector following the CMC. The appellant should not be disadvantaged by that failure. Similarly, in relation to the LFA comments of 30th of June that were withheld until 6th of July, we say that was unreasonable. Whilst we note paragraph 28 of the inspector's pre-inquiry note, sir, we will be seeking for the attached materials submitted yesterday to be admitted. If the council has any technical evidence as to the deficiency in the function of the drainage as proposed, that should be tabled as soon as possible and presented at the hearing. So far as we are aware, it has none, and the appellant's scheme and evidence is uncontroverted as to acceptability. If the council wishes to persist with its Wheatcroft argument, we are instructed to add their unreasonable conduct in relation to dealing with consultation at the application stage and on the 30th of June to our cost clade. And also, if the inspector is minded to entertain any such argument that the attached material may not be admitted, for the hearing to be adjourned to allow sufficient time for the usual process of consultation and response to be completed and the LFA's sign-off obtained before making a decision in the way it should have been if the council had consulted at the appropriate time. The council behaved unreasonably in connection with the statement of common ground, and the only draft they were prepared to sign is largely silent as to drainage issues and rather unhelpful as to what the remaining issues to do with drainage actually are, other than the planning permission for the basin and the hydro brake flow control devices, and the appellant remains unclear what the council is actually objecting to that cannot easily be resolved. However, the statement of common ground is at least clear that there are no other issues other than those relating to drainage and whether that goes to the heart of the permission. The appellant's submission in respect of the heart of the permission is as follows. The parties are agreed on the legal framework for determining whether conditions go to the heart of the permission or not, and particularly the need for fact-sensitive inquiry in context, which we agree. Drainage is an ordinary matter which stands to be dealt with on every permission and which would not normally go to the heart of the permission unless there were some particular issue or concern about whether a satisfactory solution could be found. It is understood the council's original concern was misdirected about land ownership and rights, but we understand that has now been cleared up. And that was discussed at some length at the CMC. It is noted and agreed that there are decisions that go either way on this issue. To be completely clear, the LFFA's position is set out in the committee report, and I quote, "No objection, satisfied that it will be possible to manage surface water from the proposed development and it will not result in an increase in flood risk elsewhere." At no point has anyone suggested that there is any risk of there not being an acceptable solution. The general position is that conditions go to the heart of the permission where there is a particular reason for them to be imposed as pre-commencement conditions rather than conditions that can be addressed later. For instance, before above-ground works, or at all where they are so intrinsic to the nature of the development. Two examples put forward by the appellant are Bidford Grange and West End. In Bidford Grange, the issue was about impact of timber cabins in a sensitive landscape where the details clearly do go to the whole principle of whether they were acceptable or not. In West End, it is about details of materials and development in a conservation area where the same point applies. The council produced 3 decisions where drainage was found to go to the heart of the permission to counter the Ashgrove and the Oaklands decision where they did not. But this isn't a numbers matter. 3 cases don't trump 1. In the council's 3 decisions, the schemes were new schemes on greenfield sites. We submit that greenfield development is potentially more sensitive and more uncertain whether a solution can be found. Ashgrove and the Oaklands, produced by the appellant, was also a greenfield site, but it was an infill plot between existing dwellings and an adjacent recently constructed new dwelling. That is an order of magnitude less likely, order of magnitude less risky than the much larger developments in 2 of the council's examples. We do accept that the 3rd example given by the council is a single dwelling, but the common thread of all the council's examples is an entirely new drainage system and increased flows. All the council's examples are an order of magnitude more sensitive and uncertain than the appeal scheme. The appeal scheme is not greenfield development and is essentially the reuse of the existing drainage scheme that has been serving the nursing home with no issue for many years. Yes, there is a new build element as well as conversion, but because of the reduced flows arising from the change of use in the nursing home, the overall effect is no net increase, in fact, a substantial decrease. This fundamental point, and see Appeal Document 1.10, has not been controverted by the council. This isn't a new drainage scheme with increased flows. This is an existing scheme with mild updates and reduced flows. Our submission is there was never any serious doubt as to the acceptability of the technical details, notwithstanding the council sabotaging the process to secure agreement before the appeal was submitted. There is no doubt that an acceptable scheme can be found and that the appeal scheme is an order of magnitude less to the heart of the permission than Ashgrove and the Oaklands, where drainage was found not to go to the heart of the permission, and several orders of magnitude less to the heart of the permission than the council's examples. In our submission, the details were acceptable at the time they were submitted by reference to the applicable guidance. The old guidance can be applied now, or with minor amendments, they can be acceptable now under the new guidance. They simply don't go to the heart of the permission. It appears the council, having got the land ownership rights point wrong, and at that point raised no issue at all about the technical details proposed, it has felt unable to objectively consider the matter in the fact-sensitive manner required and has been looking for issues where where there have never been any.
So, do we need to go on to the rest of the stage?
It's just costs.
Yes. So it's costs, relevant to costs applications. Park that for later.
Yes, the only thing I would say is the point that I mentioned earlier, that in the council's draft cost claim, their reason for not considering the materials submitted yesterday is that they claim never to have visited the site where the existing drainage system operates. I would invite you, sir, when you're considering their submissions about the heart of the matter, to take that into account and to consider how fact-sensitive inquiry has been undertaken by the council if they have not looked at the subject matter of the condition. I have a suspicion they actually don't know there's an existing system and they don't understand how mild the updates actually are, which is, if it was a greenfield system, that, okay, orders of magnitude different. This is so simple, nothing to see here, really straightforward. My client's been held up for a year over nothing.
I should have said earlier, this document with the options 1 to 5 in, I don't think it adds anything new. I think it potentially is useful for us to clarify what's going on. So I'm going to accept that as an inquiry document, and that will be inquiry document 1, this list of various condition options, which means that Mr. Charles's opening submissions are inquiry document 2. Thank you. Ms. Hutton.
So thank you. I'll just circulate these. So I'm conscious that you asked for opening submissions of 5 minutes, so they're necessarily less detailed than what we've heard.
Thank you.
These short submissions provide a brief overview of the Council's case to the inquiry. They address the following topics. So first, the parent permission has expired because it was not implemented prior to discharge of conditions relating to surface and foul water drainage. The appellant's reliance upon an updated drainage proposal, including suds basin on land outside the road boundary, cannot be accepted. Because you lack jurisdiction, plans have not been subject to assessment as to their impacts, and a lack of consultation. The application should be dismissed as the foul and surface water drainage scheme originally applied for is internally inconsistent, does not provide key details, and does not comply with local and national policy. And D, even if the updated proposal is accepted, then there's insufficient information for it to be assessed from both a drainage perspective and also in relation to its other impacts. So on Friday, the appellant sent 2 cryptic emails to the Council. The Council sent the appellant an email setting out the legal provisions and case law it would seek to rely upon in the appeal, and as part of this explained that it would argue that you, sir, did not have jurisdiction to grant consent for the amended scheme. In response, the appellant sent a one-liner, which was, "We aren't seeking to argue the drainage basin outside the red line can, if it requires planning permission, be consented by this section 73, if that helps you." The second email stated the appellant might add to its cost claim, depending on the stance which the Council adopts in relation to Wheatcroft. Additionally, an email was sent by the appellants to PINS on the 13th of July 2026, yesterday, setting out options for the drainage proposals. These have not been reviewed in detail by the Council. It's wholly contrary to the indication from PINS there should be no further written submissions. Ultimately, the Council is unclear on what the appellant will be seeking in this appeal, and so we've had the discussion about that today. The expiry of the parent permission. Conditions 6 and 8 are true conditions precedent. They go to the heart of the planning permission, and the Council would not have granted planning permission without those conditions. They do not relate to a matter of detail, but acceptable drainage, surface and foul provision is fundamental to the workability and acceptability of the proposal as a whole. The details are necessary to ensure that flood risk is not increased elsewhere, and also that foul water drainage is addressed without causing pollution. The details are not only relevant to drainage, but also the final levels of the new development. The appellant is incorrect to represent that the conditions will only go to the heart of the permission if there was doubt as to their deliverability at the time of the grant of the permission. There's no legal basis for this statement. In any event, there was such doubt here. Further, the LLFA is clear that it would have taken a different approach to the application, and all applications, if it could not be certain that the position on acceptable drainage provision would be absolutely guaranteed through the imposition of a true pre-commencement condition. The Council's approach is supported by a number of appeal decisions and also a decision of the Court of Appeal in Tesco Stores and North Norfolk District Council, where the court found there had been a failure to comply with the condition relating to requiring drainage details prior to the commencement of development. The relevant planning permission had not been implemented. As such, there is no valid Section 73 application to be decided. The amended proposal. So I don't know if I need to address you on this. This is the drainage basin. I think because inquiry document 1 has been accepted, I might just read it out, if that's acceptable. On 29th of June 2026, the appellant provided the Council with an updated drainage technical note, which included an amended drainage strategy. This includes different plans from those which had been applied for, and which include a large drainage basin outside of the red line boundary. The Council objects to this amendment First, sir, you have no jurisdiction to grant consent for substantial development out with the red line boundary. It's contrary to the operative part of the planning permission, which here includes the application documents and plans, and therefore cannot be granted under section 73, and that's in line with the case of Fisk in the Court of Appeal. Second, the basis sits on an area of the site which has not been visited by the council. No assessment of its impacts or mitigation required. This includes in relation to landscape, archaeology, arboriculture, and ecological considerations. Third, the provision of built development in this area would be inconsistent with other details, either applied for or approved under the parent permission. Council's already approved landscaping and ecological plans under the parent permission's conditions. This Section 73 application proposes the approval of details relating to archaeology, tree protection, and contamination risk. However, none of these assessments and details cover the area of land on which the new basin is proposed to sit. And fourth, sir, it would be procedurally unfair to allow the amendments. Council has not had sufficient time to address the proposition, including through a site visit. Similarly, the LLFA have confirmed it does not have the time or resource to review the proposal in any detail. Others have had no opportunity to comment at all. This includes the Environment Agency, internal consultees, and the general public. Turning to the merits of the application proposals. The Council has confirmed it takes no issue with the details provided in relation to conditions 3, 13, 14, 15, and 18 of the parent permission. However, this is subject to there being no expansion of the development area to include the drainage basin. If there is expansion, then the submitted details are inadequate because they do not address the new area. With regards to the acceptability of the drainage details as originally applied for, the Council gives significant weight to and relies upon the LLFA. The LLFA have raised fundamental failings of the proposal, including that they include conflicting designs, and therefore cannot lawfully be attached to the permission, do not include any supporting calculations, and even without this information, breach a number of minimum operational standards, the 19th of June 2025. The LLFA has also confirmed that the application also breaches the previous requirements which existed at the time of the 2021 consent, DEFRA non-statutory technical standards on sustainable drainage 2015. The 2015 standards overlap in part with the 2025 standards, particularly relating to greenfield runoff and peak flow. The EA has also raised concerns in relation to foul drainage. The proposals will therefore fail to comply with local and national policy. This means that the application is contrary to the development plan when considered as a whole, and material considerations do not indicate that a consent should be granted other than in accordance with the development plan. So I pause there because there's an issue which I raised with Mr. Charles this morning, that there's also a concern that the drainage proposals as applied for conflict with the hard and soft landscaping details which have been approved by the council. And so I'll address you on that later. I understand the appellant's position is there isn't a conflict. But that would be indeed another concern. And of course, it's also relevant to the true condition precedent issue as well. The appellant has not provided any response to the LLFA's concerns. It does not dispute that the designs are conflicting, missing key information, or contend that its designs meet relevant policies or standards, or provide any reason why it's acceptable for its design not to meet relevant policies or standards. The appellant's sole response has been to rely on an amended drainage proposal, and that's the one that came in on 29th of June. As set out above, this cannot be accepted by you, sir, as a matter of law. And even if it were to be accepted, it does not contain sufficient information for it to be assessed from a technical perspective, therefore not been shown to be technically workable, acceptable, nor to meet relevant policy and guidance. Further, the LLFA has considered the proposal further and considers that it has not been demonstrated to meet the relevant standards. And that then, in addition, it hasn't been assessed. And I've made that point. Overall, neither the originally applied for proposal nor the updated proposal are acceptable. Foul water and surface water drainage are fundamental to ensuring the proposal will not increase flood risk elsewhere. Drainage will not lead to unacceptable pollution. It's an issue which goes to the heart of the acceptability of development in both local and national policy, and therefore consent should not be granted. And then I've just put the Council's objection to the late introduction of material on the 13th of July, and that we would address you on it, and we've discussed that today.
So it's 11:40, it's high time we had a comfort break. I propose we adjourn until 12 o'clock, and then I'll sit through to somewhere between 1:15 and 1:30, and then we'll have lunch. Hopefully that's okay for everybody. Okay, until 12 o'clock, the inquiry is adjourned. Thank you. It is 12 o'clock and the inquiry is resumed. Is Mr. Moore coming back? Okay. Okay. I was going to ask him, but you might well be able to answer the question, Mr. Davis. Is the local community's position that the assumption of SIL liability casts doubt over the works having commenced on the 5th of June? Is that the only piece of evidence you're referring to?
Yes, there's nothing else.
Okay, thank you, that's helpful.
Could we put it in evidence then, sir, as we've got it?
What?
The seal notice saying that it was dated the 5th of June.
Well, my next question is to Mr. Murray, is can he explain how Mr. Davis has come to have the SIL liability notice with the 6th of June on it? Can you explain the situation with the dates, please?
Due to the late start on site and the rush start, I spoke to Lack. He started the work on site. On the 5th, we then got the SIL form signed and dated for the 5th, and that was submitted to the local authority, but on the following day, on the 6th. Scott Carey came back to me at that point and said he wanted it amended, and at that point we changed that SIL form to the 6th, and a second form was then submitted.
So why did that happen?
Because you can't submit a SIL form retrospectively. So it was submitted on the 6th saying the start date happened on the 5th, and the council said you can't submit one saying that, you have to submit one saying it started on the 6th if you're submitting it on the 6th, which as a matter of law is correct.
So you submitted it on the 6th?
Saying works had commenced
saying
on the
works
5th.
Commenced. Okay.
And then the council sent it back and say you can't say work started on the 5th, you have to say they started on the 6th. So it may well be the parish council has only seen the one that says the 6th because the one that says the 5th was sent back. But we have the one that says the 5th because that's what we've sent in.
Okay. Okay. Mr. Carey, is that what happened, do you think? Do you recall?
Yes, I think I can confirm that, corroborate that. We asked, for it to be dated the 6th, because the 24 hours that the SIL officer would have required, and can't do it retrospectively. So.
Okay, so you've seen the one with the. Okay. Okay, thank you. I think that's all I want to ask about that. Somebody from the council. Is it possible that the works that were done previously to the existing building could also have made a material commencement of development?
The council are of the view that they weren't. They were internal works only. The appellant and enforcement had many discussions about this at the time because of complaints received about work starting on site and were informed, and there was, Ms Denton may be able to confirm, but 1 or 2 site visits which confirmed that the works were internal only, so it didn't constitute a commencement.
If I can briefly add to that, I had been the person who complained about potential commencement of work, and Joanna Denton came back and commented that the internal work didn't constitute commencement of development. I checked the legal position on that and the case law around it. And I agreed with her that it didn't. Our property looks out directly over Wealdhall, so I was keeping a close eye on the property to see whether anything that, in my view, did constitute commencement of development was happening, and nothing did. So the work was ongoing extensively for most of the year for which the planning was valid, but none of it constituted commencement of development, and I think very deliberately didn't do. That's my personal view.
Thank you.
Could the council please comment about the roof?
Sorry, just a moment. Just on this point, and I'll let you comment in a moment, but it's been described that there was a new floor that was laid internally and the laying out of flats, the laying out of the flat layout internally within the building. Now, I understand it's all internal work, but is it possible that that sort of thing can commence development?
So if I'd like to be able to speak to that, at the site visits that I undertook, the circulation spaces still existed. They hadn't been divided into apartments at that point. They were still open areas. So no, we did not consider at the stages that we visited or I visited that those had become separate dwelling spaces, or even beginnings of the framing out. There was a lot of repairs that had to be done to the roof, which would have been constituted a repair. There was scaffold, there were works externally.
And when was the last time that you went in?
Let me just have a look. I was there in the March, 17th of March 2025. And then the next internal inspection we weren't able to arrange until, is that the September visit, Scott, that you and I went to?
Yes, 10th of September 2025, site visit between myself, Mr. Carey, Mrs. Denton and Mr. Here. Mr. Murray and Mr. Charles also attended via Teams as best we could with the reception, I think, at the time.
Okay.
And we did see, we saw evidence there of foundations, but obviously this is after that June cut-off.
Had internal works to lay out the flats been carried out by that stage? Do you recall?
At the September visit, sir. I'd have to look back at my photos, but I think the internal spaces were still open.
Okay.
Yeah, I don't recall them being flats at that point. We didn't go around the whole building.
No.
But a lot of the works we saw were sort of those internal repairs that had been carried out and starting to make that progress, but they hadn't been, as far as I recall, hadn't been set out into flats.
If it's at all helpful, I was approached by an insurance loss assessor because there was a major insurance claim for damage to the building. Now, I don't know what ultimately happened on the claim. Probably relevant were the several complaints that I've made to the police about the building being left open. So lead was stolen from the roof, tiles were stolen from the roof, all of the internal pipework had been taken out, the flooring had been removed, the staircase had been removed because it was good oak quality flooring. I didn't go into the building personally, But I know that the quantum of the claim, I think, was around about £500,000. And as a result, a lot of work would have needed to have been done inside the building to restore it.
Mr. Charles?
Yes, if it helps you, sir, we're not really, when we said we were reserving our position about other works, it's not so much about the works in the main building. It is more about the lodge. So there was a arson in the lodge, and that has a new roof fitted. The main discussion with the council had been around whether the lodge's new roof implemented the permission as regards the lodge, and it was thought that that was going to be agreed, and then as the deadline loomed, it wasn't agreed, and then knowing we had the deadline, that's why we dug the foundations. So we will show you the new roof of the lodge. The complexity is that it wasn't intended to put a new roof on the lodge necessarily. It only was required because of the fire, but the new lodge is to the new design, so it's not entirely clear whether that does or it doesn't, but we'll happily show you the new roof on the lodge, and you can see that that's a very extensive piece of work. And then the second element is there's a wall that had to be demolished to get access for the diggers in to dig the foundations, and that was done before the deadline as well.
Where was that, sorry?
It's next to the place where the foundations were dug, but we've led with the foundations because we thought that was the easier and obvious thing, and that's specifically anticipated, and it was done entirely for the purpose of implementing the planning permission. Mr. Here knew what he needed to do and when. If we'd reached agreement about the lodge roof amounting to implementation, we wouldn't have bothered digging the foundations, but as the deadline approached, that wasn't agreed, so the foundations were dug. But as a matter of fact, there is also demolition of a wall, which you can see on
Okay.
site.
Why would you say that the lodge, works of the lodge were not sufficient to implement the permission?
Just as a matter of law, sir, I think Mr. Charles just said that it wasn't intended to put on a new roof, but that was required because of a fire and repair. In order to implement a permission, there has to be a material operation comprised in the development. So it would have to be a material operation implementing this permission. So repair to an existing building, refurbishment to existing building wouldn't, in the council's view, qualify.
And the response to that is what we're relying on is the dormers, which I understand are different to the pre-existing dormers and are the dormers shown on the approved scheme. If we need to verify that by reference to approved plans on the site, we can do that. But that, as I say, that wasn't our main case.
No, I understand that's not your case in this case. Just sort of a slightly hypothetical exploration of what may or may not constitute commencement. Material operation in the development, is it possible that internal works, reconfiguration of the floor layout, for example, to provide flats, could be a material commencement? Not suggesting it happened in this case.
So there's a list of works in section 56(4). So construction and erection of building, any work of demolition of a building, digging of a trench, obtain the foundations, laying of a main or pipe, operation in the course of laying out or constructing a road, or change in use of the land. So in my submission, one, there's obviously, I'm not sure exactly what had occurred, how much work had been done. The question might be, was it sufficient to materially change the use? And in the council submission, no, because what you wouldn't have had there is dwelling houses which could be lived in. You might have some internal works, which would be lawful. Internal works are lawful in any event, so long as you don't, they're not development. So there would be a question mark over whether this had happened under the permission, and B, there wouldn't be a material change of use.
Yeah.
Yeah, this topic comes up quite a lot in practice, and I've got a lot of experience of dealing with it, which is why I advise the client not to rely on it. I think we would generally say if an internal reconfiguration gets as far as making provision for a kitchen, bed and bathroom you don't require people to move in order to establish commencement of the residential use, but we're way, way short of that level of work. So we can't argue that the residential use had commenced, and the internal works that we didn't need planning permission, which is why they weren't enforced against. They are in the nature of internal works that wouldn't have needed planning anyway. Hence, we didn't rely on that and wisely dug the foundations. The roof, as I say, and the wall would be our fallback position if there had been any doubt about the digging of the foundations, which we don't think there is.
Okay.
Sorry, can I just clarify? Mr. Davis mentioned the property had an insurance claim. That was actually prior to our ownership. The property had already been stripped out and it was in a pretty poor state. We started work on it in October 24. That's when I first met Jo, because she came out due to people saying that we'd started works, but we were just trying to secure the roof. All the internal works started from about May onwards.
Okay. Thank you. I don't think I do. Thank you. Okay. Moving on to some of the principles around pre-commencement conditions and conditions precedent. So generally speaking, what tests should be in my mind when considering whether a condition goes to the heart of the permission? Ms. Hutton, you or someone from your side.
So yes, so you're right, does it go to the heart of the permission? And we would submit that the High Court in Meisels, Secretary of State for Housing, Communities, Local Government, which is included in the Statement of Common Ground, provided a very useful test or guiding star, which is something without which the authority would not be content to permit the development at all. And so it's an open textual matter of judgment for you, taking into account all the relevant considerations. But we would say that is a useful test for you to apply.
Okay.
So we broadly adopted the council's legal note. I didn't know I was going to be facing council today, but I think the law is pretty clear that it is a matter of fact for you, sir. We alighted on the statement fact-based inquiry because it does depend on the facts. It is clearly the case that not all pre-commencement conditions do go to the heart of the permission. It is a known epidemic of a gazillion pre-commencement conditions being imposed, and as you'll know, sir, they now have to be specifically approved before they are imposed, although, you know, quite what happens if you say no, you just get a refusal, so it hasn't really done anything, but it is a major problem. Here, it is a total mystery why a single-year permission was imposed in the first place. Allegedly, it was to speed up the development, but of course it's had entirely the opposite effect and caused all of these problems. I don't think I can add that to my cost claim, but it was clearly...
I don't think it is helpful to me. So.
No, but it's just, you know, we ran out of time and everybody tried to do it quickly. Mr. here didn't get the permission. He bought the site with permission. He acted on everything as fast as he could. Everything was submitted in time. The council didn't progress the drainage condition because it thought there was a land ownership problem. So in the 2 weeks before the permission expired, it wasn't impossible that the LFFA could have signed it off, but they weren't even shown it because the council was insisting that they didn't have to do it.
So I understand all of that. So back to my question. Tests that are in my mind.
Not all pre-commencement conditions go to the heart of the permission, or Whiteley wouldn't have established anything, so it's a matter of fact and judgment for yourself, sir. I personally like my sliding scale argument. At the top, there are some that obviously do go to the heart of the permission, and I've given 2 examples, and there are some that obviously don't, and we say we fall into the obviously don't. In the middle, you have a range of decisions. The council's come up with 3, we've come up with 1. The one that we came up with happened to be my case, so I know quite a lot about that. I don't know why there aren't more decisions where it's decided that the matter didn't go to the heart of the permission, but my suspicion is it's so blindingly obvious that why would anybody argue about it? I don't know why in Ashgrove and the Oaklands the council decided to pursue the point, because there was nothing wrong with the second house, and the inspector was entirely happy to conclude that the conditions didn't go to the heart of the permission, because it was simple. There was a row of houses, one of them had been built. The one next door, one had been built without complying with the conditions at all. When the second one came to be built, the council said, oh, you haven't discharged your drainage conditions. A Section 73 was made to regularise the position, and the inspector said, drainage doesn't go to the heart of the permission. There were a number of other routine matters on that permission that hadn't been complied with. It was a number of years after the first house had actually been built, but I thought that was an entirely obvious and sensible decision. The council's examples are all greenfield development. Two of them are much, much larger schemes. One of them is for a single dwelling. I don't know enough about the detail to know why in that particular situation a single greenfield dwelling was thought to go to the heart of the permission, but I'm assuming there must have been some doubt as to whether there was a solution. And in that situation, greenfield development is all new flows and increased quantity and flow rates. The startling difference here is that the development results in a reduction, 50% in the amount of foul. Now, we're not sure whether the council have ever understood or accepted that. That was a document submitted earlier on. It's 110 in your appeal submission. Perhaps they can confirm today whether they do accept that or not. And the flow rate for the, as submitted, existing on-site scheme brings it down from the figures I quoted in my opening, which is about a 90% reduction already. So in my sliding scale analysis, this seems to be right at the bottom end of the sliding scale of risk and likelihood that matters go to the heart of the permission, because it's so simple and straightforward and so obvious that there was no danger of not finding a solution. And to be clear, we're not arguing that you don't need to show what the solution is. It's just, do you have to show it before you put a spade in the ground? And the reason for pre-commencement conditions in my submission, sir, is to stop councils being held to ransom. If you made everything pre-occupation, you build the building, and as you come to occupy it, you produce a substandard drainage situation, and the council's held to ransom because the building's already there, and they're then forced to accept an unreasonable solution. We're not proposing that here.
Yeah.
We're very happy for it to be moved back, because it's not, does it need to be discharged at all? It's, does it need to be discharged before a spade is put in the ground? Yeah. Is there a harm that would arise from digging the foundation trenches before the drainage details are, you know, so for instance, in certain circumstances, you might have to move a building if the drainage solution can't be achieved with the building in that location.
You mentioned the Ashgrove and the Oaklands. There's not actually any commentary in that decision about why the conditions were not true conditions precedent. So in putting together an argument and saying, you can rely on this, sir, look, it's not a pre-commencement condition, how does that decision help you?
Well,
other than it just being a statement that drainage is not always a pre-commencement condition.
It was a very brief decision. It was written reps, I think. I don't think we had a hearing or anything. So it informs my professional judgment, sir, because I was there and I know all about the scheme. The schemes, if you want to know about the detail of them, you know, are all a matter of public record. I think the inspector quite rightly concluded that in that situation, drainage didn't go to the heart of the permission. It was a house in a row. It was pretty easy. The house next door had been built with an unapproved drainage system with no problems, and the drainage scheme that was submitted was in effect the same as the one that was already there. That was no problem in the next house in the row. I don't really know why the council contested it, and we needed to go to appeal on the point. In that case, the council was running, or had initially started running, a case that the drainage details were unacceptable, but then changed its mind and found that they were acceptable.
Okay, so the council later found that the details were acceptable.
Yeah, although again, it does get a bit more complicated, sir, because you might have spotted that was actually a refusal, and the reason why it was a refusal is because there wasn't a condition requiring the drainage details to be approved. It was just an approved plan. So what happened in that case is after the appeal decision confirming that the details didn't go to the heart of the permission, we then made a section 73 to add a condition specifying what the drainage details needed to be submitted, and then we did a section 73 to vary that condition to make it a post-commencement approval of details. So there was quite a complicated matrix there, but the inspector was very clear that the failure to discharge that pre-commencement condition shouldn't be the sole reason for frustrating that development, and it was ultimately consented and ultimately built, and everyone lived happily ever after.
Okay. There's a common thread that strikes me through the council's examples that a new drainage system was required.
Sorry, just to finish off, the other element I just wanted to say is at the application stage, there was no suggestion that there was a issue with drainage. I quoted...
Are we back on the current application?
Yes, on the original application, there was no suggestion when the application was approved that there was any anticipation of a potential problem with drainage.
And I'll come back to that
I quoted the LFA's
all right,
consultation.
Mr. Charles, I've got a number of questions. If there's anything left at the end that you haven't said, by all means say it. But if I can try and work through my questions. I'm not going to ask that now, actually. I'll come back to that later on. Back to the general case law concepts. Other words crop up in certain judgments and decisions, things like, and some of the appeal decisions that you've circulated, things like the conditions are not of such significance or don't prejudice the purpose of the condition. Are they relevant things to have in my mind?
So, yeah, well, it is an open texture judgment for you, and there is actually there's little legal guidance on this. As I say, Meisels, I think, is the closest we get. And so you have the full quotation in the Statement of Common Ground. And the full quotation is actually, there must be scope for saying the intended function of the condition was to prevent the development of work before the condition was fulfilled. That will be the case if the condition goes to the heart of the planning permission. If it does, it's a condition going beyond the detail of a matter that agreed in principle. It is instead something without which the authority would not be content to permit the development at all. And so here, I hear what Mr. Charles says about there were no in principle concerns raised at the planning permission stage. But of course, that's almost always the case. But the LLFA and council are there content to proceed so long as there is the assurance of the pre-commencement condition. There is no legal basis for saying, well, it can only be a pre-commencement condition if there are concerns that a satisfactory solution might be found at all. That finds no support in either case law or appeal decisions.
So can you just say that again?
So
no legal basis for saying that?
Saying that a condition will only go to the heart of the permission if there is a particular issue or concern about whether a satisfactory solution is possible. So that's not the test. But you can take into account a number of factors. You can take into account what's been produced as part of the scheme, whether it was possible to discharge the conditions, etc. You, of course, sir, can take into account the many schemes that have been put forward today. You can also take into account, sir, whether it goes to the heart of an issue in planning policy. So we have a clear national policy that development should not increase flood risk elsewhere and should be acceptably drained. So you can take into account those are on-off policies as opposed to open-textured. So you can also take into account apologies, I've lost my train of thought. Yes, you can take into account the nature of the site, and you'll have the council's view on that. This isn't simply plugging into an existing proposal. In relation to foul water drainage, you can clearly take into account the fact that the proposal is not to just plug into the sewer, it's to have a bespoke solution for foul water drainage. And so what is also relevant is the impact, the wider impact of the detail. So when a surface water and flood water drainage is being consented, it also goes to other details, not only acceptable drainage, but it goes to the final levels of a proposal. It also goes to the hard landscaping and soft landscaping strategy. It may also have a bearing on layout, appearance, design, as we've seen from proposals now to include additional development off-site. So we would, I'm just saying the factors that you may take into account. You have the council's position on those.
Looking at condition 6, and you just touched upon the original LLFA response to the when they first looked at the application, the very first application to develop land back in 2021. And the LLFA explained in their statement, their 30th of June statement, that when they first considered the original application, they had sufficient evidence that, subject to technical design, the development would meet sustainable drainage requirements. So what were they able to establish at that stage? What did the LLFA establish at that stage? And what were you looking for?
So at full planning stage, it's slightly more than proof of concept. We consider it as sort of functional design as opposed to a technical design. So the full application is determining the site layout. So the drainage scheme needs to work with the site layout, with the levels sufficient to prove feasibility, and essentially demonstrate that it meets all the drainage standards at that time. So at the point of the full application, the LLFA was content that it was possible through further technical design to achieve those standards, subject to planning conditions requiring that technical design.
You recommended conditions were imposed, they went on. So what extra detail were you then expecting to receive that you didn't have?
Essentially, a more thorough design. If I speak in REBA stages, a stage 4 design, which is technical, which essentially provides all the information to build it. As opposed to...
So REBA stages, so the Institute of Architects?
Correct.
So they have guidelines. Okay, fine, carry on.
As opposed to a conceptual coordinated design, which does not. So it's a question of a comprehensive design. You can't separate drainage from levels or surface finishes or construction details. So it should have a suite of drawings, calculations, statement setting out the design and how it meets all the standards. I'd expect to see detailed finish levels, detailed drainage plans, detailed construction details, all working with the site layout in plan with surface finishes as necessary.
Yes.
Thank you. There was a suggestion that the drainage issues weren't raised at the time of the first application. And that is incorrect because drainage was raised by all of the residents and by the parish council, and the comments repeated at various times during the application process. There are 2 points about why drainage is relevant here. The first is that we are on something known as the Wadhurst clay. So the area doesn't drain well. And downhill from where Wealdhall is located is a railway line. And the railway passes underneath Clearview's property, underneath my property, in a cutting. The cutting at the entrance to that tunnel, where Clearview is, and immediately downhill from Wealdhall, has been prone to repeated collapse, closing the rail line for days on end. And Southeast Water, the railway company, has done a lot of work around there. So drainage is important from that perspective. The second point is it's not simply about whether there is a sufficient volume or not. The drainage is envisaged to drain into a pond lying on land that isn't within the applicant's control. And a comment made by Michael Halou repeatedly is that the legal agreements are not written in a way that just widely allows the use of that drainage. It has conditions which could be debated between lawyers, but planners are not lawyers. So planners, in our view, took a path here by putting a condition in that required agreement.
Yes, I'll come to that in a little while.
Okay, thanks.
But, okay, thank you. I understand the context and underlying geology is helpful.
So can I just ask Mr.
yes.
French, he hadn't quite finished.
Yes.
Can I just ask him to add the level of the assurance, at what point the assurance comes that a scheme is workable?
Yes, that would be helpful.
Yes, I'd just like to add that it's only at discharge at condition stage with the full technical design that we're able to confirm that the strategy and technical design meet current standards and can be built and be effective. At full planning stage, it's sufficient to be confident that it's possible. So it's a difference between a feasibility and actually designing it through and demonstrating it.
The difference between feasibility and what were your words, sorry? If you can remember what you said.
I've not said it very succinctly, but the difference between proving it's possible and actually proving that the final design meets the standards and is acceptable. There's a lot of detail that comes in the technical design that you wouldn't want to put an applicant to at full planning stage and create a sort of full technical design at planning stage only for it to be rejected on some other matter.
So in this case, do you know what was outstanding that you wouldn't have? What didn't you have? What assurance did you not have? Sorry, this is a terrible question. What assurance from what you were provided with at full planning stage? What more did you have to be certain that this, or reasonably satisfied this would work?
So I didn't personally review the application at full planning stage, but from what I've seen of that submission, it was a proof of concept and not a technical design. So the detail would need to follow to prove full buildability and that it meets those standards. For example, the levels design wasn't there, the construction details weren't there. There was a question about the point of discharge and how it finally reached the watercourse, whether at full planning stage there were pipes shown from the existing pond, I believe, to the watercourse that now have been removed.
Okay.
So there were some aspects that the LFA were confident should be feasible, that needed to be fleshed out and proven.
So, Mr. Charles, from your side, heard things like levels could be quite important.
Yes, sir. So, just to respond to those, so, I mean, I think Ms Hutton has slightly done my job for me. Is this about detail of a matter that's agreed in principle? We are clear that it was agreed in principle. The Parish Council are correct that initially there was an LFA objection on the original application. More details were submitted, and then that turned into the no objection quote that I gave you earlier. And this is part of the issue over the iteration of the scheme over time. It has been supplemented and layers of detail added at each stage. At each stage, the LFA has asked for more details. They haven't said anything that's been submitted is incorrect or doesn't work or fails. It's just a constant process of, thank you for all of this, can we have some more? And so we go on and on and on. The key point I would point to in measles, another quote, is that this is a fact-based inquiry of fact. Sorry, a fact-based inquiry. So your view about whether it goes to the heart of the permission is based on facts, and I have hinted at this already, but I would invite you, sir, to, when you listen to the council's spirited defence, they have not been to the site. I don't believe Mr. French has been to the site. He didn't do the original application review. Ms. Hutton hasn't been to the site, and Mr. Carey, I think, is saying in the cost claim that he hasn't been to the site to see the existing drainage system. The reason why you don't need to produce lots of information about the existing drainage system is it's all there, it all works. There's not a lot, you know, the bit outside the site, no work is being done to it. It's all there and you can inspect it.
Yeah, and I'll come on to the details of the scheme itself after lunch.
Coupled with the fact that this is a large reduction in flows. This is not about new additional flows. I think the council have completely misunderstood. They thought it was a nursing home plus 9 dwellings. It is not. It is a nursing home turning into flats plus 9 dwellings, 50% reduction in foul. So I think the starting...
Is that right?
It is,
I've
yes.
got a question on that later, but there's a report that says...
Document 110, Document 110 in the appeal package.
Document 110. That's
Nursing homes are huge generators of foul sewage because you have all the residents that never leave, plus all the staff, plus lots of laundry.
Yeah, I understand your submission on that, and you've said it before, but the...
It's not me, it's our technical experts.
Your team has said it before. There is a document that
I think it's Appendix E.
says there'll be an increase in flow somewhere.
Yeah.
Yes,
So it's Appendix E to the
Yep.
29th of June 2026.
Yep.
So total existing foul loading 0.745 litres per second. This is peak, these are peak loads. Total proposed 1.558. And you'll have seen the Environment Agency's concern that existing infrastructure is not sufficient to deal with the application.
So it would be helpful if the council concerned their position on document 110. We know that report says that. It's appended, not because we're saying it's correct. It's appended because we've explained why it's not correct.
Okay, so where do you explain why it's not correct?
I'll pass to Mr. Mercer, who can explain the detail behind that, but it's in the 29th of June submission.
Just have the title of document 110.
I think it is. It's a articlous headed letter to Mr. Here of the 9th of September. It's 2 pages long.
Yeah, so in that letter, we did the flow and volume calculations based on British loads and flows, where a residential/nursing care home has a flow rate of 350 litres per person per day. We didn't actually account for any staff either as a measure of sort of a conservative approach. So under the existing situation, we didn't allow for any staff. And then for the proposed, it was done based on standard residential flow.
So this was a new piece of work, was it?
That letter was done in response to the LLFA response to the discharge of conditions. The original, so the Appendix E in the 29th of June document is the original submission for the discharge of conditions that was done by others.
Yes.
It was included in Appendix E as sort of a historical note, primarily to give reference so that our report wasn't replicating existing situation, reference to the original planning application. But when we looked at the flows, we looked at the existing care home, say through British Flows and Loads, and stated in there that there's, I think it's a 48.5% reduction.
So can you explain again, perhaps a little bit more clearly? I'm sorry if I haven't quite understood the point, but why? How have you got to a different figure? You say a reduction, but the previous consultant who looked at it said there'd be an increase. So why is there a difference?
I'm not sure what calculations they used, whether they just did it by head. Apologies, my PC has gone very slow.
So have you looked at what they did at all to try and work out how they got there?
Yeah, when I looked at the calculations they did probably a year and a bit ago, but I don't tend to like relying on other people, so I would redo them, or I did redo them myself, and then just used mine and referred to that just in the appendix.
And so that bit of work was commissioned at my suggestion because I have some practical experience of dealing with this issue on other sites, but also because what I observed is that the council's starting point was that, quotes, in Wealdon, all pre-commencement conditions go to the heart of the permission. And we had in the early days quite a lot of work to do to shift the council off that position to entertain that there is even a likely question. And you've got that correspondence in the appeal situation. What we felt was happening was having come up with that argument and that position, and I understand, I hear it from councils a lot, all pre-commencement conditions go to the heart of the permission. That's not correct at law, but it's difficult to budge them off the point. They were then looking for reasons why they felt it go to the heart of the permission, and their concern that this was new development and extra flows, I knew to be incorrect from my other work, so we commissioned that report to knock it on the head.
So someone from the council, the position that Mr. Mercer's describing, that as set out in Mr. Chowdhury's letter, basically he's redone this work and he's found a different figure. So can I rely on what he says in his letter of the 9th of September?
So we're in a difficult scenario, so we don't have a specific foul water drainage person here. The most recent drainage technical note provided by the appellant has the increased drainage requirements within it. The Environment Agency was consulted on the Section 73 application documents, and its view, in its consultation response 16th of June 2026, is that, one, it's said there should be connection to the public foul sewer. They've said the issue of connection to mains aside, if the applicant were to proceed with a non-mains method of foul drainage, the existing treatment system and infiltration system would not be appropriately sized for the proposed development and in line with current standards. So it's clearly the Environment Agency's view that the size of existing infrastructure is inadequate.
Or is it possible that it's old and doesn't meet current standards?
Well, it says not appropriate sized for the proposed development, and in line with current standards, a compliant drainage field will be required. So it's very specific, and I think Mr. French can add to that.
Mr. Davis.
Oh, sorry.
Sorry, yeah, sorry, no, sorry, okay.
I just say, I can speak to this in generalities as a drainage engineer.
Yes.
The LFA isn't a statutory consultee on foul water drainage, only sustainable drainage. But
Understand.
I know that the rates proposed would require an environmental licence from the Environment Agency, so we would want them to comment on the suitability. The limiting factor on amount of flow is the ability to discharge it. So through a drainage field, it would be the percolation rate into the subsoil. And I imagine this is why the existing system doesn't end at a drainage field. Drainage field is essentially a foul water soakaway, where it filters through the soil. I understand the existing system has a drainage field and then discharges further on to a reed bed and then the pond and then presumably overtops to the watercourse. So what they would look to confirm is that the system's adequate now for the flows under the current standards and guidance, which is in the building regulations. So what I'd advise the council is that they seek advice from the Environment Agency as to whether the proposal is suitable.
Sorry, so just one more point on that. This letter is, of course, 9th of September 2025, which is well after the pre-commencement condition was imposed. So in my as we're looking back at what were the council's intentions, would they be content to grant the permission without a pre-commencement condition? So whether or not, years down the line, the appellant can make an argument that there might be some reduced flows is actually of little relevance, because the most relevant point, the most relevant time point is the point of the grant of consent of the parent permission. So, and it's relevant that this, 9th of September 2025 letter came after the previous calculations.
Okay. Yeah, I understand. Mr. Davis.
I wanted to comment two things. Firstly, on Mr. Mercer's report. I'm not an engineer in this area at all, but I reviewed it just for the base assumptions. And there's an assumption of the number of beds in the care home that I cross-checked with the Care Quality Commission's most recent report. And that indicates a significantly lower number of beds in the care home. The care home could not occupy as many beds as Mr. Mercer has used. The second point questions whether there is a difference between the wastewater, which is caused by washing, and the true foul water from the toilet systems that discharges through the system and the pipework underneath the land of Michael Halloum.
Do you want to say anything in
Yes, could you
response to
just
that?
clarify the order of magnitude? How many beds are you saying were there and how many has Mr. Mercer used, please?
I think something like 20% difference.
If it's the difference between a 50% reduction and a 40% reduction, I don't consider that to be material. It is a fact that that document 110 has been uncontroverted since submitted in September, so if the council disagrees with it, they have had a lot of time in order to comment upon it, and they have chosen not to do so. The Environment Agency's concerns we have dealt with. There is no requirement to connect to the mains drain because of the distance involved, and yes, of course, we need a permit, but that follows on later, and matters of permitting are not subject to the question of whether planning permission should be granted, unless there is some suggestion that there is some reason it couldn't be granted, but we don't consider there to be any grounds that the permit would be withheld. And I think sort of the direction we're heading here is whether the council is making an allegation of incompetence of Mr. Mercer because we've provided the information as required
I don't think that they're saying that. I just asked a question about whether he could explain
That's
the
fine.
difference.
I'm
and
very
he-
happy for him to
he-
explain
he-
whatever you need to.
He explained that he hadn't analysed or he hadn't been able to work out.
But the
how
two points
previous
we want to be very specific
consultant
about,
had
and I
done it.
did press the council in the statement of common ground process, and I did ask for technical discussions between Mr Mercer and Mr French, is the 110 document accepted or not? No answer, so it's uncontroverted, that's where it stands. And what exactly is the LFFA or the council saying is wrong with Mr Mercer's design, apart from repeated requests for more information, which we say just feels like trying to backfill their other bad arguments.
Well, I'll come on to
other
what may or
issues.
may not be wrong with the
Then the
design
last point
in
I
due
need to
course.
address is from the parish council about land ownership, which we spent some time on at the case management conference. Our position remains. There is no doubt that we are entitled to continue to use the existing drainage system, and that infrastructure is present. I know nobody from the council's been to look at it, but it's all there. It doesn't need lots of explanation. It is there, and it all functions correctly. There is no doubt in our submission about the land ownership issues, and unless there are legal submissions coming from over there, that's not accepted. And my belief is that the position was established at the case management conference that land ownership issues, in any event, are not relevant to the question of the grant of planning permission, because even if there were a land ownership issue, we may sort it out after the event if we needed to, but we're not accepting that there is one or that there is anything to be sorted out or any doubt or any concern. It is a fact that the council thought there was a problem, and this is the root cause of the issue. When the condition discharge was submitted before the planning permission expired, the reason why the council didn't consult the LFA on it and we didn't have a chance to secure the LFA's approval before the 5th of June was because the council thought there was a land ownership issue. We have now got to the bottom of the council dropping that point at the CMC, but it is very unfortunate they wasted the 2 weeks that were available to secure discharge then on the wrong issue. And I completely accept the spirited defence of the council's position being presented today, but it is by people who have not inspected the subject matter that we're
Right,
talking
yeah,
about.
okay, and I understand what you're saying about that. So, as you've taken me to this legal point about land ownership.
Sorry, may I just say one more thing before you go on to land ownership, sir, if that's okay?
Okay.
Just on the one about site visit, LFA is very clear that in order to know whether a scheme is workable, that's about plans and levels and including existing and proposed and all of that. So visiting a site will not help you with that. So I've gone back and checked the outline strategy at the planning permission stage, and it'd be helpful if the appellant could confirm this. That was proposing a new on-site treatment package system. So it wasn't the proposal wasn't simply just to be using all existing infrastructure, and indeed it currently isn't that either. So we can have a lot of discussion about flows, but we would say actually that's irrelevant because this is not using an existing scheme and leaving it at that. Further, there's of course the entirely new 9 units needing to be connected to both surface water and foul water. So in the council submission, the flows is not the answer to the point.
Yes. Now, I've got questions about all of these things that I haven't quite got to. We've gone in a slightly circuitous route, and I've lost my order of thought.
Sorry, the first question is about whether the package treatment plant is new. There is an existing package treatment plant. It's described as new, but it probably ought to be renewed rather than new. There is some question as to whether we could continue to use the old one, because it's actually not as old as we thought it was, but it is called
But that's
new.
not your proposal.
My client is, very keen to satisfy everybody and do what's right, so we've called it a new one. It might be a renewed one, i.e. a new one on the site of the old one, rather than a new one in a new location. But
Right.
I know it is described as new, which is perhaps a little bit unhelpful, but we're just trying to satisfy everybody that we're not cutting corners or trying to do something
Okay,
that's unacceptable.
that's not really helping me either.
I'm just
I
telling
think
you
you've
when
got a
we-
proposal for a new package treatment plant.
Yes, but it might be renewed on the site of the existing as opposed to new in a site where there isn't a package treatment
Okay.
plant at the moment. And we can show you that on site, and it comes partly from the council not having visited. The second point is there is a spirited attempt to suggest that there's some great complexity around levels or the development being complicated or difficult or great site designs being produced that don't exist at the moment. The scheme plans show the levels of all the buildings on the site. They sit on the site. The land is pretty much unchanged. There is no great earthworking excavation. It's pretty much just built where it stands. It is not complicated. There's a topo that shows what the levels are. It's all very clearly understood. The existing system has been working fine within that constraints. It's all known and understood. There's nothing exciting to see. There's no complexity. There's no difficulty. It's all there and it works at the moment. It's just a light refresh. The constantly suggesting that there's some complicated and difficult development with some potential catastrophe arising is not the case, and it is very clear on site that the scheme is easy, simple. There's no great change in levels or difficulty in this.
Okay, understand. This levels information that's all on the plans, was that on the plans at full planning stage? Was that on the plans at full
The finished floor
planning
levels are on the scheme diagram.
Sorry, on which plan?
I mean, I don't have all of the whole suite of plans from the full planning, nor do I need them. But
Whether or not the council shared them with the LFFA, I don't know, but they are part of the application.
Sorry, of the planning application by
Correct.
2023?
Correct.
If you could just give me, I've got it on.
Mr. Murray will look them up for you. It's the plan we looked at the other evening with the finished floor levels on it. If we can come back to that.
yeah, well, you come back to that. So, Mr. Hellu. Give Mr. Chucks turn your microphone off.
So just an observation, we keep hearing many times about the council not having visited the site. I'm not sure how many times the appellant has visited the site. I mean, important point to note here is that to access the site where the existing sewage treatment lies requires access through private land, which I own. I bought Clearview in 2022. Since then, there's been no engagement with the developer or their consultants. No one has asked for access. There is a right of access to maintain the existing sewage infrastructure, but nothing more. There's certainly no permission to build a new outfall, which I think was the initial intent in the initial application. The construction of a new outfall would be over land I own. And I've said repeatedly, as did the previous owner of Clearview, that that permission would not be granted. So that is a legal matter. I don't think it's for the council to intervene in that. I think the condition was put in place initially with the intent that it would give us time to discuss that, but no one has engaged with me. So not once have I been told about access to the land, so I think there has been potentially people going onto my property, doing work, surveying without me being aware. That's not right. And then the assumption that everything is fine and everything's agreed without any consultation, engagement, discussion, frankly, I find very offensive. And I would really sort of say today, I found out today that there's an intention to have a site visit. I mean, again, this is private property. To go and see where the existing sewage treatment facility lies requires access through private property, which the appellant does not own. So, you know, frankly, I think there's a lot here that needs to be carefully considered, and there needs to be proper discussion.
And can I just be clear, you're not suggesting you own the site of the private sewage treatment work that exists at the moment? Because the title information is in front of the inspector.
Mm-hmm.
And just to be clear, there is no
Sorry,
construction.
let him finish, please. I understand. Now, as we've gone back there, I was going to park it for the moment. As we've gone back there, let's go on to this ownership point. I'll let you comment in a moment, Mr. Charles. This part of Condition 8 that includes the need to provide evidence of an agreement to cross third-party land. What is the council's position here? How is this relevant to planning? Full stop. And what is the council's current position?
Well, so it goes to deliverability of the proposal, and it's exactly this type of point that one would seek to deal with a Grampian or a pre-commencement condition. And so yes, there seems to be very clear uncertainty as to whether actually these proposals are deliverable. That goes to whether this is a true condition precedent, and the particular complexities on deliverability go to this issue. Because, if I can explain it this way, if you have a pre-implementation condition, then you have a certain period of time, the implementation period, in which to sort out the scheme, the relevant details. If you haven't done that in time, the permission expires, new permission is applied for, issues that have arisen can be perhaps addressed at that stage. If an appellant is able to implement and then have an indefinite amount of time in which to discharge the conditions, so take drainage as an example, the appellant can then come back for a number of years, scheme upon scheme upon scheme. The council is unable, through discharge of details, to interfere with the principle of the development. And there is therefore a risk, clear risk, that the appellant can argue, well, we haven't been able to arrive at a acceptable drainage scheme which would meet relevant policy and standards, but you've granted consent for this, and therefore you are going to have to approve something that is substandard. It's the pre-commencement condition and the time limit on that that offers some assurance against that issue occurring. So that's why deliverability is also relevant to this issue.
But why does the council need to be satisfied that there is a legal right to carry out the development? Because that's not normally something. That's normally left for the developer to resolve.
Well, so it goes to the acceptability of the proposal, because if the council, let's say this all happened as it was meant to, all dealt with pre-commencement. All of these things interact. The drainage interacts with the hard landscape, interacts with layout. If the council approves a scheme which ultimately is not workable or deliverable is probably the right phrase in this context, then there's concern about the other details on the permission. So that's the issue. It goes to the deliverability of the scheme.
And now we find ourselves in a situation where evidence was provided by the appellant, and to say, well, we do have right to connect across this land, discharge to this pond. We've got these rights. Here are the rights. I think I'm right in saying that the council is now happy that those rights do exist. Now, it's not Mr. Hellu's position, I know, but it seemed to be the council's position. Tell me if I'm wrong about that.
No, that's, yeah.
But in any case, okay.
Yeah, the council has not taken a position that there are rights to connect.
Okay. And in any case, sorry, does the council have jurisdiction to make that decision anyway as local planning authority? If there's a dispute about right to...
No, but what it does have the authority to do is make a judgment about deliverability. So yes, not the arbiter of legal rights, but it has a judgment. It can make a judgment about deliverability of a proposal.
Okay. Do I have any jurisdiction in this matter at all?
It's the judgment over deliverability, so, as opposed to making a pronouncement on legal rights.
Charles.
So I'm getting slightly cross with Ms Hutton, who wasn't at the case management conference and appears to be somewhat rewriting history. But our position is completely clear. Evidence of the agreement in place to use the rights has been disclosed. It's in the title. And the council has dropped that point. Whether or not they've accepted it is a different point. So an agreement has been produced. The council has not said that agreement does not satisfy us. It's gone silent on the issue, as it should do, because unless it thinks there's a problem with it, it does not have a case that there is a deliverability issue. We say it's irrelevant anyway, because even if there was a question, it can be resolved after the event, and it's not a reason not to grant planning permission. I'm very sorry for Mr. Hellu. He may have hoped to get a ransom payment or to stop development or to buy Wealdhall himself. None of that is relevant to the proceedings.
I don't think we need to be concerned in any way about what Mr. Hellu's intentions may be.
The council can have regard to what he said,
but
but unless their interpretation of the legal documents deduced to them is that there is no agreement, they cannot conclude there is a deliverability question, and they should not be interposing themselves between the grant of planning permission and the appellant's case. I think, as a matter of fact, the council did do that at the outset, but at the CMC, the position is completely clear. The council is not purporting to raise a land ownership issue such that planning consent ought not to be granted. And Ms Hutton is slightly rewriting history, but the legal documentation demonstrating that there are necessary rights has been provided. That is uncontested by the council. If it does want to contest it, it should have done it at the time it was provided, which was a long, long time ago, and it did not do so. And at the CMC, the position was conceded that a land ownership issue of whatever magnitude of uncertainty we have, which we say is none and Mr. Hulu wishes was something else, it's not a reason not to grant consent. And it doesn't mean that the condition goes to the heart of the permission, and it's not appropriate having a planning condition requiring a new agreement to be put in place with a third-party landowner when there is already an agreement in place. On site, you will be able to see very clearly what we own, what Mr. Hulu owns, where works are proposed and where they're not proposed. We are confident what we are doing is wholly within our legal agreements, and you don't need to be concerned about it any further, and I don't think the council should be stirring the pot or taking sides. Unless they had at the time pursued the point, which they did not do so. There is an agreement in place, it's in the title, it says what it says. Mr. Hu is entitled to his opinion about it, but that doesn't make it right.
So I'll come to you in a moment, Mr. Moore, but just on this point about Ms. Hutton's point about deliverability. So the council is not seeking to make a pronouncement on the legality of the rights. There's a position here where your side of the room says, look, we've got these rights.
Yeah.
The council says, we're not in a position to make a finding on that. It's not our remit.
Yep.
That's not my remit.
Yep.
But if there isn't some assurance, then that goes to the deliverability of the scheme. So what do you say about that? And how do you move forward?
So the council's condition asks to see evidence of an agreement. The agreement is in place, has already been evidenced. That's the end of the matter. It doesn't require a new agreement because no new agreement is required. If nobody knew what the position was or had read the title deeds or could see in black and white that the rights exist, then there might be a question. But in our submission, the matter is settled to the extent it is relevant, and we don't accept it's relevant anyway. This is not the appropriate forum for Mr. Halloo to attempt to make out that he has some rights or could injunct us or could stop us. If he wants to do that after the event, that's entirely up to him, and we'll see him in court, and that will be resolved. But it's not appropriate for he or the council to seek to argue that planning permission should not be granted on his sole interpretation of an issue that contradicts what it says in black and white. And the council's been provided with the black and white. They've accepted that they've got it wrong at the CMC and that those issues are not relevant to this determination. If now they are trying to say they have such doubt about the legal agreement disclosed to them that they think there is no chance of this condition ever being discharged, that is a very substantial and material movement away from their case.
So we're not dealing with a condition discharge application here. The discussion is whether this is a true condition precedent. The council has not confirmed that it's content with the land ownership issue. It is a matter of record that there was a real concern at the grant of consent stage. They can see that reflected in the condition itself. I'm putting it no higher than this. The land ownership position here, the complexity over that, we say adds weight to the argument that these are true condition precedents. One factor among many. The reason for that is it goes to deliverability of a scheme being put forward. And also, not merely that, but take one example. If it appears, if in fact the appellant doesn't have the right to discharge off site in the way it does, then there would have to be a new design proposed. Whether that's achievable or not, I don't know. But it would have implications for the wider design, for all the other elements. But again, sir, even if there wasn't the land ownership issue here, the council's very clear position would be these are true conditions precedent. And I come back to the submission. There is absolutely no basis in law for saying it's only if there is uncertainty over achievability or deliverability that matters a true condition precedent.
So, Mr. Charles, on this point, before I move on, whether or not you have satisfied the council that this is that there is a right to discharge, the right to discharge does the right to discharge go to the deliverability of the scheme?
So our evidence to the council that there is agreement in place is uncontroverted by the council.
Just a moment. So your evidence that there is
an
a right
agreement in place,
yes,
is uncontroverted by the council. The council raised it. I'm assuming they'd been got at by the neighbour. And we explained the agreement is already in place, and the council has not controverted that. It is no part of their case that the agreement is not in place.
Yeah.
So we say there is no question going to the heart of the permission or otherwise about the deliverability of the scheme. Ms Hutton appears to be trying to suggest at the CMC the council kept the door open to now raise that argument, but they did not. It is uncontroverted from the time we answered.
Yeah, I hear what you say about that. But my question was that the right to discharge relevant to the deliverability of the scheme?
If there was uncontroverted evidence that there was a problem with it, I think I could stretch as far as saying that could tip the balance. But that's not the facts that we have here today. In particular, doubly reinforced by the fact we are not talking about a new drainage system. We're talking about refreshing an existing drainage system. And we are not talking about more flows. We're talking about less flows. And that is also uncontroverted. Whether we're at a 50% reduction or a 40% reduction, that's not material in the grand scheme of things. So, again, Mr. Hu is entitled to his opinion, but he's not brought any evidence before you other than his opinion. He said he thinks he can do something, but you should not get caught up in that, because this is all existing. It's not new. It's all existing. The rights are there to use it. It is in use.
I understand full well that that's your position on the matter.
We're not putting in a new outfall on his land because we've already got an outfall that we're entitled to use. So it's really simple and clear, and we shouldn't be getting bogged down in this issue.
I understand your position on that.
First, I'd like to say I'm fairly offended that you keep on attacking my resident, Mr. Halu. This is a man who's living peaceably in his house and is just trying to prevent more sewage being poured into his garden. So I find it quite offensive the way you're talking about him. And I will raise again that I would have preferred if we'd been a Rule 6 counterpart and then we could have maybe had representation ourselves, because this is, I think it's quite offensive, actually. So I understood, and I'm a layman and I'm not an expert, that this was about a condition Rule 8, which was that there was meant to be an agreement about this, because we knew this was a problem when the permission was granted. The parish council opposed the permissions in the back garden because it's in an area of natural outstanding beauty, now a national landscape. It's also part of VB 37, which is a protected area, which is only one of 12 in Wealdon. And it's highly visible, and it's above a railway, and all of these things. It was given, but it was given with this condition that this issue with sewage would be sorted. And there was a year for your client, or for the appellant, to come here, or speak to Mr. Halu, and get some substance. To then just claim that because there's no agreement, somehow that's an agreement, is preposterous. It starts bringing this whole thing into disrepute amongst the residents. If they see a condition that says condition 8, you must agree this, and then you're just going to say, well, we didn't agree it, we didn't even speak to him, therefore we're just going to ignore it. That's ridiculous.
We didn't speak to him because he wants money. I mean, that's extremely offensive.
But it is offensive. That's not the point. He has said he doesn't want this development because it's going to detrimentally affect his land. That is his right as under land ownership. I take your point, that's not a planning point, but within the planning, there is a deliverability argument. And the condition was clearly put. The condition was clearly put. They should have sought to discharge it by speaking to Mr. Halu.
Yeah. So I understand that's the position that we're in, and I've had a discussion about that, and to be honest, I think I've heard enough about it. I understand your point of view. Mr. Davis. Okay.
I apologise if any offence was caused. I'm not intending to cause offence. I understand your frustration. It is extremely unfortunate that the council expunged all of this from their website, so
Okay.
you couldn't see what was going on.
Mr. Charles, I hear your apology to Mr. Halou, and hopefully Mr. Halou will accept that. I don't need you to go on and explain the background again.
No, but can I just make one point?
Because I think we're all getting to the stage where we need to stop for some lunch.
But can I just make one point, which is that what we are trying to deliver here is a very significant improvement. This is not a development that is going to result in more raw sewage going on to Mr. Halou's
I also
land.
understand that
what
that
he is
is your
objecting to is what he wants,
position.
which is a better drainage solution.
Understand.
Which he won't get if this is refused and the care home reopens, because it could carry on as it is now. This is a very substantial...
Mr. Charles,
project.
I understand that you believe there's a betterment to be had here. Thank you.
Right, thank you. I wanted to come back to the wording of the condition, which we seem to have drifted somewhat away
We've
from.
drifted quite a way around a few things, unfortunately.
Well, we have. The condition says, and I'll just read it, and I'm reading the relevant sentence in it. The details shall include evidence demonstrating an agreement in place to allow an outfall to be constructed across third-party land. Now, at the point when the application was considered, the figures, if I've understood the position correctly, suggested that there would be a higher volume of liquid passing through, and therefore the condition seemed reasonable. There is nothing in the documentation that's been put forward to suggest that that allows an outfall to be constructed. There may be some case to be made about an outfall continuing to be used. But if the appellant felt during the period when the planning when the planning was extant, that this wasn't required, the correct thing to have done would have been an application to vary this condition. That was not made. As far as we are concerned, planning has expired, and there's now an attempt to go back and do the work that should have been done during the period when it was valid at some point later.
Thank you. Okay, I think I've heard quite a lot about that point. I haven't, unfortunately, got to the end of, well, I may have done, because we've gone on a fairly circuitous journey through my questions. I need to go back and look at what I haven't asked, that I do need to ask. So I may or may not have wrapped up the discussion on the sort of principles around pre-commencement conditions. So there might be some questions outstanding on that, but I'd like some time just to pause and reflect. We'll take some lunch, then we'll come back, and principally I'm going to ask some questions about the drainage proposals after that, but might just have a few outstanding points here. Can we do 3/4 of an hour? Which will take us to 2:15. So we're going to adjourn for 45 minutes. Until 2:15, the inquiry is adjourned. Thank you. Okay, good afternoon. It is 2:15. The inquiry is resumed and we will continue. You'll be pleased to know just one outstanding matter from this morning's discussion. And that's back to the question of the change of use of the existing building, which is obviously part of the scheme. It's a scheme, part change of use, part new build. If commencement could take place through the change of use of the building, I'm not saying that that might have happened, given what has or hasn't happened inside the building, but if that happened and went first, why would drainage need to be agreed before that happened? So if the appellant chose to make a material change of use of the building, care home to flats, and didn't continue with the other new build for the time being, why would they need to have agreed drainage first?
So the scheme is one scheme. The scheme is one scheme as a whole. So it's always been proposed to be one consent. There's no consent to only build out part of the scheme. And that's relevant because there are matters, for example, like landscaping, which again relates to the entirety of the proposal. One can't simply just salami slice off one bit and say, this is now the scheme. It is one, so it's incorrect to consider it in separate parts. The second point is that, yes, it's a change of use, but I think there's no suggestion of the care home use being able to be resumed using existing drainage. I mean, we note that the permit for foul water drainage was revoked in 2021 by the Environment Agency. And I'll ask Mr. French to comment, but I don't think there's ever been any proposal that you could isolate the drainage element. You know, again, in light of the entirety of the appeal scheme, you could isolate the drainage from the care home and still comply with the conditions. The conditions are very clear that it is for the entirety of the scheme.
Okay, thank you.
Is that
Happy?
right?
Yeah, I just need to make sure I understand the question. We generally don't advise that you can sort of partially discharge a condition for technical design. So if they were seeking to implement the planning consent just for a small part of the development, we'd still want to see the designs for the entirety of the development to ensure it wasn't implemented and then construction carried on without those designs being approved.
Okay.
I think that's an interesting question, sir. If the scheme had only been conversion of the existing building, would any drainage condition have been imposed at all? Presumably the application would have said existing drainage to be reused, and if there was no suggestion that the existing drainage didn't work, there wouldn't have been a case for a condition. I think the more interesting question is the other way round, is the new build element, is putting in the ground floor slab. Do you need to have the condition discharged before you get to that point? In our catch-all conditions, sir, we've suggested occupation of the conversion and, did I say above slab or above ground? Anyway, I can't remember. Above slab for the new build element. We think there's no reason that you can't do all of that without the drainage being approved. Question, could we have also occupied the main building without it being approved. On the basis that it's going to be a reduction in flow, actually you probably could have done off the existing system, but you are also getting into parking areas and things like that would be changed in association with the new build element.
Okay.
But also, just to be clear, we don't believe there's any problem with the resumption. If we haven't implemented the permission, we're entitled to restart the nursing home at any time, and we don't anticipate any problem getting a new permit in the same way that we don't anticipate getting a permit for this current scheme.
Okay.
So can I just ask Mr. French to comment on the comment that if it was merely a conversion, there wouldn't have needed to be a drainage
Yes,
condition?
okay.
So the test would apply is if it is development that requires planning consent, then paragraph 182 of the MPPF would apply. And what that says is if drainage is affected on or off the site, then it requires sustainable drainage. So it would only be if there were no external works, no change to the roof, no change that would affect drainage on or off the site. It would be the only case that it wouldn't need drainage design. And if it needs sustainable drainage, then it would follow a typical path of functional design at planning stage and technical design at discharge of conditions, unless they chose to submit a technical design at full application stage, and that may not then need a condition.
Okay. Thank you. Any final word? Can I move on? Thank you. Right, so some detail about the drainage regime at the site then, please. Does the existing surface water drain into the reed bed drainage field and then on into the pond? Or, if no, can you explain the existing drainage regime?
Sorry, from the surveys, it's a combined system, the sewer down the road. So all surface and foul drains down the access road to the PTP reed beds, basin reed beds, and then to the pond and out.
So surface water from the building, so from the roof and the hard standings?
Yeah, yes, yeah. See, there's a few connections into a ditch along the southern boundary that just discharge freely into that, but that falls down towards the basin and reed bed as well.
So, just a moment. So it goes from, so there's a combined system.
Yeah.
Does that go to
the PTP?
To the PTP?
Yeah. And
then what happens?
And then through the drainage basin and the reed beds. But there are smaller areas at the south of the site where there's a few buildings that have rainwater pipes that just seem to discharge straight into the ditch adjacent to the southern boundary.
Do you know what goes straight to the ditch?
That's only rainwater, not foul. So surface runoff from roofs and hard paved areas.
Where's that rainwater come from?
So the buildings at the south of the site and the paved areas.
Yeah. So straight to the ditch. Okay, so you say it goes from the reed beds, no, so from the PTP through the drainage basin to the reed beds. So this is the drainage basin that's outside the red line that we've been talking about this morning.
Yes.
from the reed bed, what happens then?
So there's a series of pipes from reed bed at a higher level down to a lower one, and then there's a pipe from the lowest reed bed through the field down to the watercourse to the south. And that's through Mr. Halu's land.
Pipe, so it's piped from the reed bed
Yes,
to the pond.
to the pond, yeah, and then there's a pipe from the pond down to the watercourse.
Then pipe from, okay. Okay. Are you content that that's accurate? We can obviously have a look later.
So, as a rule, we don't rely on having a look. We need topographic survey, drainage survey by CCTV, and plan-based evidence on the planning file for everyone to see. I think my recollection is that at full planning stage, the pipes referred to from the pond to the watercourse were on the plans, and then at discharge of conditions stage, they were not visible on the plans. So that was one criticism we made at discharge of conditions stage, is that we still didn't have topographic survey and sufficient evidence of what was on that southern parcel of land and how surface water was discharged. So I can't say whether that's correct or not.
Okay. Yes.
As far as I'm aware, I don't believe any survey work has been done on any of the land which is mine beyond the reed bed, i.e. the pond and then a pipe going out. I wasn't aware there was a pipe going out of the pond into the watercourse. And I say that simply because no one has asked for access or permission to go onto my land to perform such a survey.
Thank you. So does the existing foul drainage, just to make sure I do understand, go the same way?
Yes.
Yes.
Sort of
Good. So
it's the same pipe. So
combined system,
yeah.
same pipe, through the same PTP,
Yeah,
to the basin, to the reed bed,
correct.
to the pond.
Yes.
Okay. And the point being that once it is beyond the PTP, any discharge can be treated as if it were surface water.
Yes, once it's out of the PTP, the foul would be technically called final effluent, which is clean enough to discharge to watercourse or groundwater. And that's obviously combined with the surface water as well.
Could I ask a question?
In a moment, just let me catch up with my note. So just make sure I noted that correctly. So it's clean enough to be discharged to surface water, to surface water, is what you said.
Sorry, yes.
Yes.
When you say it's clean enough to be discharged, but isn't it meant to be discharged into a running watercourse?
It's only, yeah.
Sorry. That's one of the points in the environmental permit. I think it's 6.5B for the EA. You can, if you don't meet the general binding regulations, when you wouldn't actually need a permit, you apply for either a standard permit or a bespoke permit.
Okay.
And the bespoke permit covers a dry ditch or watercourse, providing there's some water, and I think from memory it's the final 10 metres of the pipe outfall needs to be perforated to allow any treated foul or final effluent to have the ability in dry conditions to drain to ground. Oh, sorry.
So does this mean that you'd need to have a perforated pipe in Mr. Halu's land then?
question for Mr. Helou, sorry. Do you own up to the watercourse? Yeah, so it would need to be in that section, I believe, but I would need to check the regs to see whether it could be higher up.
But what we're sort of saying is, we don't know if it's there. You've not been on his land, and you're claiming that this would work. I don't see how that's possible.
We're sort of getting into what's proposed now, so and I'm interested to know what is proposed now. I think what I've noted is the suggestion that we've got the current situation goes from the pond via a pipe to the watercourse. So I don't think there's any suggestion of discharge to ground through a perforated pipe. Not in the existing setup.
No, sorry. When you discharge into a dry watercourse, or part of the year dry watercourse, the final, I think it's 10 metres of the pipe should be perforated.
Oh, okay.
Now, because there was an environmental permit in place prior to 2021, if that was applied for and was applied correctly, that should already be there. The perforations in the pipe should have been done to meet the permit, providing it was done correctly.
So this watercourse that we're talking about is a dry watercourse, is it? Or partially dry? It's a ditch, yeah.
Because my understanding is that it's meant to run into a moving watercourse, and this is a big problem we have in Wealdon, because it dries out in summer, so you don't have moving water. So then you've just got effluent into his dry land, which sits on the surface because it doesn't drain. And that's the problem. So, I mean, I'm not a drainage engineer, but my understanding is when this went to committee, the councillors wanted to defer it because they were unsure about the drainage, because they thought it was core to the whole discussion. So the councillors wanted to defer it, and it was suggested that this condition be put in so that more time could be used to discuss it and find out the detail. I think the big concern is they've had a year, there's been no works done. So we're still talking about maybe could it, and this is on Mr. Helou's garden. So I think this is the issue as I see it.
Okay. Park that for a moment, unless there's anything you want to say about it. The need to discharge to running water, I suppose.
Sorry, you don't need the running water to have a permit. It's got to be a watercourse that runs at times during the year. As I say, the water or the final effluent that's discharged is under the PTPs is clean enough to discharge to ground or to a surface water body, ditch, watercourse, that would be part of the application for an EA permit.
Which you would need,
Yes.
should you be
Yeah.
using this system.
Yes. But that's also what was in place before it was revoked in 2021. So they had a permit to discharge at that point.
But to be clear, that has been revoked.
Mr. Helou, I don't think I need to get involved in this to any greater extent, but does this watercourse run at certain times of year?
It's a trickle even in the winter, is my recollection. And then, the other point I would make, reference to this pipe from the pond to the watercourse. The watercourse is not all on my land. I don't know where this pipe runs. I've never seen it. As I said, I don't know who has actually been down there to do this work and give us all the assurances we need to feel comfortable with the plan here. I mean, that's...
I think where the ability to discharge and the nature of the watercourse and what it needs to be, I think is a matter for the Environment Agency under a permit on a subsequent day is my gut feeling there. Sutton.
Well, I'll ask Mr. French to respond to that point, but of course this is surface water as well as foul
Yes,
water.
yeah.
And foul water is a planning issue because it's one of the pre-commencement conditions. Could we just ask the appellant what survey work it has done, if any, to establish the existence and nature and working order of the relevant pipe? Because we're being told that this pipe is there, it would need certain characteristics, etc. Looking back at the original documents submitted with the planning application, it appeared that there was actually a new pipe being proposed, with a replacement pipe, replacement head wall. So just need to be absolutely clear on when it said that certain pipes are existent, etc., what is the evidence for that?
Would you like to answer that question?
Yes, we've all been to have a look at it and it's there, so we'll show you on site. And we're primarily relying on the fact that a permit was granted before. And to the extent anything new arises for the new permit, that's a permitting matter, not a planning matter.
So have you seen the pipe from the reed bed to the pond?
You can see the line of it very easily. We think it probably was in a channel before it was a pipe, but...
And have you seen the pipe from the pond to the watercourse?
Sorry, we have seen the pipe from the pond to the watercourse, and we did look at the pipe from the bed to the pond, yeah. It's a bit overgrown, but you can see all the component parts there.
I'm not going to get embroiled into when and where and how, but I'll see what I'm able to see later. And if you want to have a discussion outside this room, you can do so.
Sorry, could I ask Mr. French? I was going to
Yes,
pass
sorry.
on before.
Yes, the other question.
There we go. Only to say it's quite important that that pipe is there or something replaces it, because it's not acceptable to discharge surface water over land from a development that's called flooding. And so it is important that it's there. We would want to see survey, CCTV survey, that it's fit for purpose and in use.
Okay. Now, the proposal, so that's established the baseline of what's there, what you believe to be there. Did this Section 73 application, when it was initially made, did that propose the same drainage details as was submitted to the council for the discharge of the condition? Okay. Yes.
I think it was, and I'm sure I'll be corrected if if wrong, but the original discharge and condition submission was the one that the LLFA commented on. And then further details were submitted after the permission expiry, which were the ones that were not commented on because it was considered that the application was no longer valid.
So do you think that that's what was submitted with the Section 73 application?
I believe it was the second lot of information.
The second lot of
which was
information.
submitted, I think it was around July 2025.
Which might have included the 9th of September letter?
I'll confirm to you in a second what date it was submitted.
So we think the answer is 2 weeks before expiry, scheme submitted, not consulted on, not dealt with. No, then it was consulted upon after expiry. Yeah, so consulted on after expiry, response to those comments submitted and prepared, and that's what's carried forward. I think it's the same scheme, just more information about it, rather than a different scheme. Is that fair? Yeah. So we didn't change the scheme in response to LFA comments, we just added more information. So layers and layers of information.
And with the exception of the additional information that is within the drainage technical note, condition 5, Roman 1, that's basically the information. Oh, and Roman 7, which is the 29th of June letter. That's the scheme that was submitted.
No, the original discharge of condition information was submitted on the 21st of May, which just before the expiry of the permission. It was consulted on before the expiry of the permission. The LLFA came back after, and I think it was around the 13th of June. They made their comments where they had issues. And then an email from the agent on the 8th of July with supplementary information. And I believe these are the details that were submitted with the variation of condition application.
And can you just confirm for me when the LFFA were consulted? You say it was before the 5th of June. When was that date of when the consultation was sent? We know the consultation response was received 13th of June. When was it sent to the LFFA?
It was on the 2nd of June. So it wasn't straight away, but it still went. There was still, when the application was submitted, there still wouldn't have given the statutory consultation time that the LLFA would have had to comment. So I don't quite think it's fair to say, had they been consulted straight away, we could have resolved the issues and got everything sorted by the time the permission expired, because it wouldn't have been possible. But maybe that's conjecture. But it wouldn't have given them the statutory consultation period that they would have been entitled to.
Other than that they did in fact respond within 2 weeks. So if they'd been consulted straight away, the response would have come in before the 5th of
Okay,
June.
I don't need a back and forth across the room about when things happened. But
Sorry,
those-
I think it was consulted on the 4th of June because we were exchanging emails up to that date.
okay, I don't think I need to know that right now. Thank you. So these details were they also the details for the foul drainage? Same package of information.
Sorry, just confirming yes.
So, Mr.
Sorry, can I add, sir?
Yeah, sorry.
I think the original LFA comments queried why the original submission, the surface and foul were both going into the PTP. So as part of that resubmission, we separated out that so the surface would bypass the PTP, as opposed to putting too much water and potentially flooding the PTP. And then that's remained sort of through the design since then.
And when do you think you made that change?
That was the 8th of July 25, that submission went in.
Okay. And that's part of these details. Right. Okay. So when that scheme was first submitted and you first looked at it when this scheme, the Section 78 scheme was submitted, what do you think is wrong with that scheme? Why are you not in a position to approve it as submitted with the application?
I mean, there's multiple points to raise. The first one is that the submission included different and conflicting designs and calculations, and we cannot approve multiple designs. It needs to be one design, one set of calculations. So that's one aspect.
And what were those differences?
So that's that the section 73 was the discharge of conditions list included the ardent design that was submitted at discharge of conditions stage and the articless design as well. They have different calculations attached to them. They have a slight different point of discharge for the surface water. They're clearly not the same designs, and they're accompanied by different calculations. So it's impossible to approve multiple designs. Separate to that, the comments that we made at discharge of conditions stage about the design not being progressed enough, not a full technical design, that applies to both the ardent designs and the articless designs. The outlet to the existing pond and how surface water ultimately discharges to the watercourse wasn't proven in either design. And then judging the key aspect of the previous standards, the non-statutory technical standards for SUDs, the greenfield runoff rate, that's a point of policy that they should be restricting their peak runoff to, hasn't been proven.
And what do you mean by that?
What you should do in this circumstance is to demonstrate that a pro rata by area greenfield runoff rate for the drained area has been calculated and applied to the design peak flow control rate. So although some work was done at full planning stage, that work needs to be reconfirmed at discharge of conditions stage or a section 73 to remove those conditions with no further opportunity to review designs. We're reviewing that in the same way as a
Yes.
technical design. So in both cases, that work's not been fully evidenced. So it's not the same as saying it's categorically wrong. We're in a state of insufficient evidence. And the sort of burden of proof is very much on the applicant to prove it meets policy and design standards. So we can't give benefit of the doubt. We need to see the evidence. The other technical design points I've mentioned already about proposed levels, which you can't separate from a drainage design. It's very much a levels and drainage design. There are aspects where it's important whether the permeable paving, particularly if it has a flow control on it, it's important what the proposed surface gradient is. And just for a complete design, we need to see an external works design, including levels, drainage, finishes as necessary. So
So is there not a plan showing levels?
there is a topographic survey for the northern, the main site area, the northern parcel, I'll say. And there are cover levels on the chambers, but there are no proposed levels on the external works. I can't see finished floor levels on the new buildings. Yes, I can. Right. It's really the external works levels that are missing. And for the southern parcel of land, there's no topographic survey. So the levels that are shown at the outlet for the new infrastructure, we can't say whether that works with the existing levels. Yeah, and further to that, just you know, the detail of the technical design in terms of what the chambers are, what the pipes are, the construction details is not there in terms of a buildable design. So it just doesn't meet our standards for discharge of conditions.
So what's missing? So the detail isn't there, but what do they need?
So I said in my statement, there's a construction detail for a flow control device, which is an orifice plate. It doesn't show an actual size of the diameter of the orifice. It doesn't show how it's constructed in the flow control chamber, and it doesn't show any blockage protection or high level overflow or other measure to mitigate the risk of blockage to an orifice. There's no chamber details. There are 2 sections for the permeable pavement which are the same, which leads me to think that perhaps they should be showing different areas, or perhaps it's a replication that just needs clarification. There's no pipe bedding details. It's just a general lack of a sort of fully comprehensive design.
Okay. If I perhaps ask the appellant side then, look at these points in turn. The submission had different or conflicting details in the council's view. Two proposals in one.
Yeah, I think that was the Ardent report being submitted on the same day. So in the original, that was the original submission, and then we got your comments and addressed those, and then put the second revision in. But when the Section 73 was submitted, I think everything went in on the same day, so there was no sort of delineation. Yeah, so that's what the report from the 29th tried to clarify. Was the timing of submissions.
But why were there 2 proposals on the table?
So the original proposal by Ardent was included as part of their report, which was included as Appendix E to our report as sort of a reference document.
Okay.
So it was a case of, here are the LFA's comments.
So for the application discharge, there were changes between the initial discharge and the initial submission and the submission to address the LFA comments, but they obviously came in sequence with the later superseding the earlier. The problem is for the Section 73, just the whole package, it went in at the same time, so it wasn't clear the sequence of evolution from the earlier to the later, because all the information went in at the same time. Because the Section 73, the principle was it's the same as was submitted at the discharge stage, but at the discharge stage there was submission, consultation, amendment, and so you know that the later supersedes the earlier. That's entirely normal. At the Section 73 stage, it all went in at one time, so it wasn't clear what the evolution was. The evolution is explained in the 29th of June technical note that explains the evolution and what the end result is up to that point, to address the concerns from the LFA that they didn't understand or they thought there was conflict. it explains the evolution.
I see.
And we believe the points that have just been identified are either addressed in the 29th of June submission as additional information about the scheme, or if they're not addressed, it's because we don't think they need to be addressed.
Okay.
I'm just going to say pipe bedding. I don't know whether we need details of pipe bedding. I think Mr. Here knows how to lay a pipe, but that may be one that we have submitted the details for. But from our side, we say we've met all of the necessary requirements for it to be approved.
Okay.
And sorry, just to be clear, I don't know whether Mr. French is applying his standards for greenfield new development, or whether he applies a different standard when you are doing a light refurbishment of an existing scheme that is shown to operate. We say, applying the guidance, you do that flexibly. You don't impose everything on a light refresh of an existing submission. That results in reduced flows. It's not the same as starting again with a blank sheet of paper. So the levels of the site are the levels, they are on the planning drawings. This wasn't a site that was being regraded or reconfigured. Existing buildings, some buildings added, but it's not a greenfield site with no development. It's got an existing system. The initial proposal from Ardent is a bit closer to just reusing the existing system, but with some additions, where we ended up after the initial, with the split of the foul and the surface, is a bit more of a more enhanced system to achieve better performance. But it's not a greenfield site, and so we believe we've addressed all of Mr. French's comments to the extent we need to, given the nature of the site and what is retained as existing and what is being improved.
Have you had a look at the 29th of June letter?
29th of June technical note with the
Yes.
new design in.
Yes.
Yes, I have. I don't agree that it resolves all comments, no. I would disagree that this development is a light refresh or anything of that nature. It's classed as a major development. And therefore the full sustainable drainage standards apply. The fact that it's redevelopment or brownfield doesn't remove the requirements to reduce the flows to greenfield runoff. They still apply in the old standards and the current. There's an awful lot more in the current SUD standards that the Section 73 submission didn't achieve. They're closer to that with the 29th of June technical note, but if that was submitted as discharge of conditions, there'd still be a holding objection needing further information because it doesn't demonstrate an evidence and proof that it meets all those standards.
For the 2025 guidance?
All right, for both guidances, but very much more so for the 2025 guidance, which has many more standards to meet.
Both guidances you're talking about older versions.
So the old one is the non-statutory technical standards for sustainable drainage by DEFRA, I think it's 2015, and the more recent standards is the national standards for sustainable drainage, again by DEFRA, which is June 2025.
And those are technical standards?
Yeah, they are technical standards that link back to what's called the minimum operational standards referenced in MPPF paragraph 182.
Okay.
So before we go on to standards and we've addressed that in writing, and no doubt we'll come on to that. Just to clarify, I think, because we're looking at option 1 here, the appellant's option 1, I think what we've established is that even if you delete the 29th of June drainage technical note, the appellant accepts there are 2 drainage designs in the remaining documents. Because you have the original drainage statement, which is the Ardent plans, and then you have the Articulus plans. So there are 2 different, so you cannot, as a matter of law, in my submission, approve the condition as asked for by the appellant, because there are 2 different designs. So that's the first point. So the second point goes to this. If you, sir, were to approve, let's say you were to approve only some of these plans and we were somehow to fill it out, what was being approved and what wasn't, the appellant would have the right to construct what is on the plans. And the fact that there is no information, for example, as to what a particular diameter is or mancold wouldn't matter, because as long as it accorded with the approved plans, then that would be the scheme that they were entitled to be built out. There's no additional ability on the appellant's case for further control here. So, although some of the, we say that the totality of the missing information, including in particular levels and other details, is very significant. Whilst some of those details might seem fairly minor in isolation, the point is, in order for this to be workable, for the surface water, foul water to be acceptably drained off-site, all of this, the details matter. Because if one of the levels wrong, the system, the system may fall down. So it's just that point. That's why this, when specific plans are being sought, because this is such a fundamental issue, it's not a matter where it's appropriate to just be broad brush. The details matter.
Mr. French, if you were considering this as a discharge of condition application, this package, notwithstanding the conflicting information, do you think that this scheme is workable?
I'd have to start by saying which scheme. Is it the Articulus design or is it the Ardent design?
I think it's the Articulus design we're talking about, because the Ardent design, we're told by Mr. Mercer, was provided as contextual information.
So is it the 29th of June design or is it the previous Articulus design? Because the 29th of June design wasn't submitted with the MFA application.
But that's a further iteration of these. So you raise, I mean, I understand I understand the problem that you're in. Yes.
And it's also quite important whether we're judging it against the current development plan, the current SUD standards, or the previous. Although I would
let's
say,
let's ask that. If it was a discharge of condition. So if we'd never had this Section 73 application, and I appreciate that's not what's before me, but if you were looking at details to approve, reference the original permission from whenever it was, 2021, 2020.
I think it's important to have the condition in front of us.
Well, it's condition 6 of permission 559 of 21. So back to our the original development. If you were approving that condition,
Yes.
would you be looking at the current standards or the previous ones?
We'd be looking at it for a Section 73 application. We would look at the current standards.
Yeah.
For a discharge of conditions application, where the parent application was judged under the old standards, the new standards are immediately applicable, but we typically take a view on what's possible within the approved plan layout, and would be much more likely to give some flexibility, some relaxation to those standards. So fundamentally, they would need to meet the standards of the time of the parent application, and if it was entirely possible to implement the newer standards, we would be within our sort of purview to request that.
On that basis, not the scheme as amended on the 29th of June, so not with the new basin, etc., but the proposal that was put to you back in 2025.
The Ardent design.
The articless design.
Okay.
The articless design. Subject to the details that you say are missing, is that a workable scheme, do you think?
The articless design, judged against the old standards, we essentially have similar comments to our discharge of conditions comments on the Ardent design, that they need to prove, reconfirm greenfield runoff for the drained area. They need to demonstrate the point of discharge and the connectivity down to the watercourse. And the level of detail in the technical design needs to be sufficient to build. The original condition wording included a verification aspect, which they're becoming much more common recently, because it's very difficult to actually ascertain or prove that, having done an awful lot of work getting technical designs up to scratch, that they actually get built. So we would want that verification aspect repeated in the new condition wording. And if you have a vague design, it's then very difficult to hold that implementation, the works being proven to be in accordance with that design.
Okay.
So I don't know if it's helpful for Mr. French to actually look at the condition, which would be being discharged, and comment on whether these details would do that. Condition 6 is very, very detailed as to what it is requiring.
I don't know that I need that. At this stage. No, I'm going to move on. Thank you. In terms of the original management and maintenance proposals.
Sorry, sir, do I get a little
Yes.
moment on that? I don't need to say too much.
You can.
I'm very obliged.
Yes, I apologise.
I'm very obliged to Mr. French for confirming that he's found no defect, and that was very helpful confirmation, because we seem to be in a debate about layers of detail. I'm very grateful for him.
That's not
sorry,
what's being said.
I don't think. Yeah. You say he confirmed there was no defect, but he's listed a series of things that he thinks are absent.
That's exactly what I'm saying. So no identified problem, but a request for more information in a search for either clarity or problems or solutions. So it's not a defect in that there's something wrong with it, but to be satisfied, he wants more information.
What's your view, Mr. French, on?
I mean, what's wrong with it is that it doesn't demonstrate that the design meets policy and design standards. So without a full design calculations and justification, we're not at the point of being able to say what the defects are because there's a lack of information. So this is always a process. There's always several rounds of information and comments. This is common.
Okay.
Right. Correct. But what I'm saying is you haven't hit a brick wall of an insolvable problem. It's a holding objection. It's not a refusal. We're on a journey. We haven't quite arrived at the destination yet.
Okay, just a moment. Do you accept that?
I'd say that's fair. The fact that we recommended conditions indicated that the LFA was confident it was achievable at full planning stage, but without, the proof is in the pudding of the technical design. We can't say it should be able to be worked out. We need it to be proven and evidenced.
Thank you. So that's helpful. And we've got to the bottom of it's articulous, not ardent. And I'm hoping you've understood in the 29th of June explanation, we've tried to explain the relationship. We've included the ardent for background, but it's the explanation that it's articulous that we're doing. And I think you said that the June 29th does deal with some of your concerns. I just want to be very clear what the residual concerns were, because we've read your response to the 29th, and we are unclear what we need to do to satisfy you on that. Now, you mentioned one thing, where is the pipe? Okay, the pipe is there, so that's fine. We're going to settle that this afternoon. We just want to get to the bottom of what needs to be done. Now, I think this revolves around the flexibility that you apply to these guidance, because I think we agree that they can be applied flexibly. We're perhaps going to get onto this in a moment. There are certain things in here you shall do, and there are certain things you should do, and there's some flexibility to apply them flexibly, particularly in the example when it might be new development, it might not be new development. So we're into the realms of how much flexibility do we need to have to satisfy you. We are confident in our design. We just need to know what else you need us to do to get to the end of the journey.
All right, and I understand that, and I think what I'm going to say at this stage goes back to the comments that I made at the beginning, is that for the purposes of today and for the purposes of my decision, I need to focus on what was provided with the application, because I appreciate full well that things are continuing to move on and you're on this journey, and you made further submissions on the 29th of June, and we can talk about that, but that's further confused by the fact that there is this other proposal with this attenuation basin in it as well. So I think there are avenues, if I'm with you on the principal point, and I'm with you that there's a workable solution, there are avenues to further conditions whereby you still have to agree this stuff.
So we're very happy
I
to do
don't
that.
want to,
This
and
is
I don't.
The first FaceTime we've had with Mr.
I
French
understand.
in this whole process right from the beginning.
I understand, but that's not going to help me make my decision.
But this should have all happened before the appeal was submitted, and it only didn't happen.
Mr. Charles, I understand your frustration with the whole of the background. I think there's a way forward. I've got to make a decision on this appeal, and I've got to do that in an open and fair way based upon evidence that everybody's had an opportunity to look at on a proposal. And I think that has to be the proposal that was on the table at the beginning. Now, whether there is another, and there are routes, other conditions, differently worded conditions that can get you to continue this discussion. And I'm sure you are enjoying the opportunity, or would enjoy the opportunity, to have me mediate a discussion between you. That's not the role of this inquiry. I need to make a decision on this appeal.
Yes, I mean, we could suggest...
I don't want to spend hours talking
No,
about...
I agree, and we could suggest the technical experts break into a room and they might come back with an answer.
Well, they might,
but
they might
at your
not.
discretion, sir.
And I don't think that's going to happen today.
No, the only thing I would like to underline to you, sir, is the flexibility to be applied, because we think that notwithstanding Mr. French saying applying it flexibly, I'm not satisfied. I think you have the option to apply it more flexibly and for you to be satisfied. So what I want to direct you to is in the guidance where the flexibility is laid out, which Mr. French very helpfully acknowledges exists. And there are just some very helpful paragraphs I'd like to bring to your attention, because, as I say, I think it is within your remit.
So I will just say this guidance isn't in evidence,
Okay,
as far as I'm aware. I don't believe I have a copy of it.
okay.
Because I'm not likely to be approving the technical detail myself,
Okay.
I don't think that matters.
Okay.
But I am happy to take the
Can
point
you
that
just
it can
indulge
be
me at a
applied.
high level, sir, and Mr. French can
Flexibly.
shout out if he disagrees where I'm going with it. So it is guidance that applies to new development, and the question is this new development where the purpose of the Section 73 is just to regularise failure to infant scheme? It's not a new form of development. It does result in a new permission, as I explained in my opening submission, but it's not a new development. That's our opening point. Our second point is that there is flexibility built in, and I will read it out. There may be specific circumstances or constraints, such as the type or size of development, that means it is not possible to deliver one or more of the standards. In these circumstances, the opportunity to meet the standard shall be maximised and justification be developed in consultation with blah, blah, blah. And I think that's what Mr. French said, and I think we're on the same page that there is flexibility built in. Throughout the guidance, there are some things that you shall do. Principle 1 is mandatory, and we say we've complied with Principle 1, and thereafter they're all should, which involve a degree of flexibility. So I think all we're down to at the moment is, of the design that we've got at the moment, applying flexibility. Mr. French isn't yet satisfied, although he's not very clear why he's not satisfied. We say you can be satisfied because we think we've done enough in all the circumstances. Section 73, light refresh of an existing system, designed by Mr. Mercer, who knows what he's talking about. It may well be that we haven't provided the pipe bedding details, but our view is we don't need to provide that because that's so not an issue in these circumstances. We know how to lay a pipe. I give that as an example. It may be that we are still short even on your analysis. It's very difficult to gauge from Mr. French's vague comments how far short we are, and I'm very sorry we haven't had the FaceTime with him to try and close that gap, because then it would be a very simple procedure today of dunk, rubber stamp. But my submission to you, sir, is we are within the flexible zone. Mr. French might not be satisfied, but we think you can be. If you're not, we think we're very close together, and in very short order, what remains can be resolved, because we just don't think it can be that difficult. If Mr. French can articulate what he wants, we will do it. We don't think there's any full stops or problems.
Yeah.
It's just we keep being asked vaguely for more detail. We keep providing more detail, and then we're still asked to provide more detail. We can provide more detail. We just need to know of what. There was some confusion about the levels. Were asked for levels. We provided the levels for the pipes. He was talking about the levels of the ground. The ground levels are in a different plan that maybe he hadn't seen, but there's no complexity around the levels or the pipe levels or the ground levels. It's all really simple.
Yeah. Okay. Yes. I mean, the appellant's position is this can all be resolved.
So
Can it?
I would say the vagueness is in the design and the submission, not in our reaction to it. If we ask for more information, it's because it's not clear in the design what the design is and how it meets the standards. So requesting further information is not vagueness on our part. It's requiring clarity from the applicant.
Have you ever set down a list of the things that are required?
Well, that's what our consultee replies essentially do, is say what we need more information on. So we said on the 13th of June, several paragraphs on surface water drainage that called for full technical design, including drainage levels, pavements and construction details. It talks about the outlet to the existing pond and the watercourse needing to be proven. It talks about the peak flow restriction needing to be calculated to greenfield runoff and demonstrated. It talks about lack of clarity on some of the details, and it talks about the unknowns in terms of peak groundwater levels.
Okay.
So we have been clear in our comments.
So,
sorry, could I?
yeah, sorry. Can I just ask, and then you can come back. Mr. Mercer, there's the list of things that are required. So is that clear? I mean, I don't know that this necessarily furthers my decision, but I'd like to know
Yeah,
whether that's useful information to you.
it is. I think a few of them have been responded to, and it might be a case of a conversation as to how some things have been arrived at would help. But I think things like the greenfield runoff rates, we've calculated. I think you commented that they'd increased, but that's because we used FEH compared to the previous FSR. So there's just an increase, generally speaking, with FEH rainfall. I think there was some, so we, as Sebastian said, Mr. Charles said, we've done the drainage levels, not the site-wide, just because there's not a lot of changes proposed. However, we could add levels on.
Okay. And my question was really,
Sorry. Yeah.
the criticism was that you hadn't been given the information as to what you needed to do to move things forward. Mr. French has said, well, here's a list of things that we've said, and you've said to me, well, that's a helpful list, so I know what to do. So, and I'm not asking you to respond to those points in real time.
I think it's when they came, when it says levels, I would say we've done the drainage levels for the site, but perhaps like a phone call or Teams meeting to run through, we could outline sort of exactly the extent of what's needed.
Yeah.
Okay. So some of it is crystal clear, like the greenfield rates. Some of it I could put 10 levels on the site or 100 levels. So it's to what extent.
Okay. Mr. French, would you like to finish off where you were?
I just wanted to add that if there was a lack of clarity in what was required in the design, the LFA offers a paid consultation service separate to the statutory duty of providing substantive response to the LPA. So any time since the 13th of June 2025, we could have been approached to clarify or have a meeting and do the sort of thrashing out that they would like to do today. But I don't believe we can do that today. And as a rule, we don't approve designs in meetings. We'd need to see plans and drawings and calculations and take them away and calmly review them.
Is there anything you'd like to say before I go on?
No, other than, in my opinion, we're very close, and we think it is just about the extent of flexibility. There may be some miscommunication, but that is only because of the context that we're doing it in, not pre-appeal, after application consultations. And, I think, being fair to Mr. French, we are pretty close to the end destination, so even if you're not here today.
Okay.
I don't know if you're going to come back to it, but so you might recall in opening raised an issue which I raised with Mr. Charles this morning about the drainage designs conflicting with the landscaping plans. This is a crossover issue to the condition precedent and also acceptability of these designs. I have a copy of the hard landscaping plan that's been approved. I wonder if I can hand that up and just explain what the issue is.
So the hard landscaping plan has been approved?
Yes. So it's under condition 10, which was another, I believe, a pre-commencement condition.
Yeah. And you say it conflicts with the drainage proposal?
Yeah.
Perhaps we'll come to that after we take an afternoon break,
Yeah,
and you can just have a
Yes,
quick conversation
we've
with
had a
Mr.
look at
Charles about what that is.
We have done.
Oh, you have done?
We have done already,
Okay,
yeah.
We're ready to explain it.
Fine, okay, let's go ahead then.
So if I hand up the plan, and I'll just explain.
Thank you. So I'll take this then. Is this in evidence already?
I don't believe it is, sir.
Okay. So,
ID
oh, this can be ID4 then.
4, I believe. Yeah. So, if I just explain the conflict. So you see on the hard landscape plan, there is in green existing roadway to be retained and made good where appropriate. And then there's also proposed tarmacadam roadways and car parking bays. So hold those in your mind. If one then turns up the articulus proposal,
Where do I
and
find
it's
that?
drawing number 1001.
Yeah. I think I've got that open. Yes.
You can see two large areas of permeable paving. And then you have the details, the sections of the permeable paving at drawing 1002. So the first point is the permeable paving is not tarmacadam. So that's the sort of middle part of the permeable paving. And then second, of course, is the addition of permeable paving to the front of the care home building, where the hard landscaping plan is simply retention of the roadway made good where appropriate, but the drainage proposal is in fact the provision of the permeable paving.
Okay.
And the short point is that all these things are interrelated, and drainage doesn't just go to drainage adequacy, but also to appearance and materials.
Okay. Mr. Charles.
So the explanation is simple. The grey, which is the middle and bottom areas, are new hard standing. It doesn't specify in the landscaping plan that they should be permeable, but it doesn't specify that they can't. So the detail of those can be permeable paving as specified in the drainage drawing. The potential issue is the top area at the top of the site where the annotation is existing to be made good. And so that is tarmac at the moment. And the question is, in the process of making good, can it also be made permeable? There is some discussion at our side whether that is possible and the extent to which it will be made good. It's going to be subject to construction traffic for quite some time, and we think made good will probably involve relaying it. If there were to be a very fine point that relaying it with permeable paving went beyond making good, that can either be resolved by making an amendment to the approved landscaping scheme, or alternatively, if it was not to be permeable paving, we'd have to make tweaks to our drainage system to reflect that, which we think we can because we have ample capacity. But it is true that the calculations at the moment assume that to be permeable.
Okay.
So, as I say, very robust work from across the table to try and find a problem, but we don't actually think that is a problem that is unsurmountable.
Okay. Thank you. So moving swiftly on, hopefully we'll be reasonably quick here on. Was there a problem with the originally provided management and maintenance proposals?
So is that the July 2025 document?
Yeah, so the Arden,
Oh, sorry.
the Arden Management Maintenance Plan should have included maintenance requirements for the whole system, including reed bed and pond, in our opinion. A management and maintenance plan should be a standalone document, which has the approved plans in, all information that you can pass to a maintenance provider or facility manager. So we would never recommend discharging the condition on management and maintenance until the drainage design was approved, because it couldn't possibly include the final approved plans. So we didn't say a lot about condition 7 in our original comments, partly because there was so much wrong with condition 6.
Okay, understand. Mr. Charles, do you want to say anything about that?
Yes, so we're very happy once we have a set of approved plans to staple them to the back of the management plan so they're all in one place. We had understood there to be 2 defects identified. One is the detail of the, I'm going to call them flow control valves, but they have a technical name. So we produced and circulated yesterday a supplement which explains the management and maintenance procedures for those valves. So we address that point, and then if you're minded to pursue options 2 or options 3, the off-site basin, we would need a management and maintenance regime for those, so those are included as a supplement as well. If we reverted to the on-site scheme, we wouldn't need that second supplement. Obviously, if we're in the super sweeper zone, we'd be very happy to wrap up a management and maintenance plan that relates exactly to the sweeper details.
Thank you. And somebody from the council, I appreciate it's not Mr. French's field of expertise, but is there a problem, ownership and rights notwithstanding, is there a problem with the proposed foul drainage plan?
So I don't know if you've seen the Environment Agency's
About the off-site
concern
discharge?
about, yes, exactly.
About the, sorry, connection to public sewer?
So there's, yeah, the first point is about connection to the public sewer. Sorry, let me just get the...
And you've got a response from the appellant on that?
Yeah, and I'll come to that in a moment,
Okay.
and what that says and what it doesn't say, because we're dealing with the Environment Agency hasn't been consulted on the 29th of June information. So the Environment Agency makes clear that connection to the public foul sewer as preferred option must be used wherever feasible. If the applicant chooses an alternative means, it must be demonstrated that connection to the public foul sewer is not reasonably practicable, supported by written confirmation of sewage undertaker. So I'll come on to that in a moment. And then the second point is if the applicant were to proceed with the non-mains method for foul drainage, the existing treatment system and infiltration system would not be appropriately sized, and in line with current standards, a compliant drainage field will be required, need to be accommodated in the site and safeguarded from development to ensure effective use. And then making the point about discharging to SUDS would be contrary to best practice. So the Environment Agency was consulted on all of the Section 73 documents. That was where they ended up. If one takes up the 29th of June technical note with the additional information, you'll see at 3.2 of the technical note, it said, in line with the general binding rules, a connection to public sewer should be sought if there's a sewer within 30 metres multiplied by the number of dwellings on site, and then it shows the route that would be taken to the sewer. But so if you look at that, the route the appellant has chosen to take is extremely circuitous. So it's chosen to come up via the road, and then I think potentially crossing some third-party land. Of course, that is, so and it arrives at 748 metres, and it says that the relevant meterage should be 510. Now, of course, if you took a direct route, you would be well under the 510 metres. It's then said in the drainage statement that Southern Water has recommended the use or upgrade of the on-site package treatment plant. But if one goes to Southern Water's email, which is at one of the appendices to the statement, apologies. Yeah. So this makes the point that connection to sewer would require Section 106 application, dependent on lay of land, levels and gradients may require pumping station, also require permissions of landowners. And then it says the alternative to this would be a Section 98 requisition. Southern Water lay a new sewer at your cost. This could be prohibitive based on distance and illegal costs. And then it just says it may be financially beneficial to the project to consider using or upgrading any PTP you have on site, rather than connecting to the public foul sewer. So it makes the point it may be financially beneficial. It's not actually recommending that a PTP be used. So one just has to be careful about what's actually being said. And it remains unclear as to whether this evidence would be accepted by the Environment Agency. The second point on foul water drainage is the Environment Agency's concern about the drainage field and capacity. And there doesn't appear to have been any response on that point, noting that the Environment Agency was consulted on all of the Section 73 documents.
Okay.
Could I just quickly come back on that? So the drainage field, as it is currently configured, wouldn't fit inside the site. Am I right in saying that?
Sorry.
The drainage field recommended by the EA for the new sized treatment work, if that were the alternative, wouldn't fit within their existing site. It would be in Mr. Halou's site.
We've not...
Okay, well, I'll let you respond to that as you respond to the councillor's point.
Apologies, yeah. We've not proposed a drainage field, while the EA have said that that's a relatively standard feature that you would put in if the ground conditions allow. As you've said, we're on wheeled clay, so percolation is very unlikely to work as per infiltration. That's why we're looking at the discharge to the watercourse. So that wouldn't need a drainage field, that would just need treatment and the discharge. So that's then discharge to surface water as opposed to discharge to groundwater.
Okay.
There isn't any surface water for most of the year there.
Okay, well, I think that's another matter, to be fair, for the EA to...
Well, yes, but the EA is recommending that they have a drainage field on that basis. He's saying that he doesn't need one. They've recommended clearly that they do. I mean,
So,
it's here. He's saying they need a bigger package works and they need a compliant drainage field. They don't have space in their site for a compliant drainage field. And so then it has to come to Mr. Halou, and Mr. Halou is clearly saying he doesn't want to do it as per condition 8. Are we sort of, am I not understanding? Or is...
Mr. Mercer, would you like to explain?
Yeah, so as a discharge of final effluent, you would put either into a watercourse or into a drainage field, generally speaking. So if the ground conditions don't allow for a drainage field, you would then look to discharge to a watercourse. You can import and make a drainage mound where you import sand, generally with a calculated VP percolation value. That's something that we tend to do as a last resort because of needing to import material.
I think we're mistalking here, though, because you're saying it goes into a watercourse. There isn't a watercourse. There's a pond, which is static, and it's dry for most of the year. So that is why the EA are recommending a drainage field. They have obviously recommended a drainage field. They haven't said into the pond. Or is that not what they're saying? I mean, they don't mention a pond at all here. Is that because they don't understand, or is that because they do understand and have understood the lay of the land and the fact that it's clay?
Mr. Mercer, what is the proposal
The proposal is
for drainage?
discharge,
For foul drainage?
so treatment in a PTP,
Yes.
discharge via reed beds and the pond, then to the watercourse. So it's a discharge to surface water, but what we've got is in between the PTP and that point of discharge is a tertiary treatment, which would be the reed beds, which is not required as part of the permit. It's an extra. So it's an extra form of treatment within that treatment train of the foul.
Is the reed bed within the application site?
It's not within the application site, but it's part of the existing drainage that we're proposing to tap into upstream of. And it's in the ownership, but not in the red line.
I hear what you say. I noted it.
I'm just confused that the EA seems to be making a very, very clear statement, and we seem to be sort of not being clear about it. Because if there's a drainage field, it's almost a Hallou's land, which he's clearly stated he doesn't want.
So,
So it's not deliverable.
So, Mr. Mercer, to comply with the EA's requirement, do you need a drainage field?
No, we would look to discharge to the surface water without a drainage field.
So that would be putting a different proposal to the EA?
Yes.
Okay.
Yeah.
I mean, I'm sorry, but he's saying, I want to do something less good on somebody else's land.
I hear what you say.
So just for clarity, the point I wasn't particularly making about ownership one, but actually, so the EA has been consulted on the Section 73 application, so all of the documents we're discussing.
Mm-hmm.
It is clear, in line with current standards, a compliant drainage field will be required, and I can pass over to Mr. French, he says it's not just about discharge, it's also about treatment. This would need to be accommodated in the site safeguarded. In addition, the previous proposal to discharge via SODs would now be contrary to best practice. Now, with regards to the plans that the Environment Agency had, it's assumed what they're talking about there is the pond and reed bed, because there wasn't a separate basin in the Section 73 application.
Mm-hmm.
So there's a clear concern in the council's view being raised by the EA about meeting required standards. And it's not enough to say, well, we're not going to put in a drainage basin, we'll go into the pond, because that seems to be exactly what the EA has got concerns about.
Mr. Mercer, are the EA effectively saying that your proposal to use the pond is not acceptable?
Get their wording up. So the EA, in their final main paragraph, state that the existing treatment system and infiltration system would not be appropriately sized for the proposed development, and in line with current standards, a compliant drainage field will be required. Mm-hmm. So my take on that is that they are assuming that we are maintaining the mode of discharge. The previous proposal to discharge via SUDs would now be contrary to best practice, and new installation must comply with the current standards. So we're not technically discharging by SUDs. It is discharging to a watercourse through our proposals. This might be one that is, as the application for the permit progresses, with feedback from the EA, the detail would come forward there.
Do you know
As
where-
things currently stand, are the EA objecting to the proposal?
Sorry.
I don't read that as an objection, is my take. It's I would say, advisory.
And to be clear, sir, that is a permit matter, not a planning matter. Do you know why they've said that the current package is inappropriately sized? Do they think it's too big or too small?
I don't know. I can only assume that because there's larger or more buildings on site, they're assuming more buildings is more flow, as opposed to when you drop the intensity of the care home to flats and you reduce flow, that's not been looked at because no application has yet been made with the calculations.
Thank you. And then just to clarify another point, because it is a little bit complicated. PTP, existing basin, existing reed bed is on our land ownership. The pond and the second reed bed is on Mr. Hula's ownership. And the outfall to the watercourse, as opposed to the outfall to the pond, is on Mr. Hula's ownership.
Yeah.
It's very clear on site, though, sir, and when you see it, it will become completely clear to you. We're not proposing any works on Mr. Hula's land. The works are all on our land.
So I don't know if this is relevant, but I've had EA permission to discharge to a canal which was deemed as a stationary water body, even though it did slowly flow out to a river in sort of similar circumstances to this. So there's precedent at least.
Mr. Haloum.
I'm sorry, but I mean, it's just simply not good enough. This has been going on for years. In those years, I mean, I live with a family next door, as do my neighbours. We've had crime, we've had squatters. This planning application, despite the council's best intention and hard work on it, has just proven to be not deliverable. There are all sorts of issues on site. They're starting to reoccur. We're sitting here today, months after the application lapsed, in our opinion, debating technical points that could have been resolved a year or 2 or 3 ago. Why are we today sitting here talking about these technical issues? The environmental agency, which is the opinion I care about the most, because this is land we use for leisure. It is our garden, it's an extended garden. Welcome for everyone to come and have a look at it. Having any risk of pollution there is just unacceptable to me. And I'm sitting here today listening to this and sort of saying, well, I'm the person who's going to be impacted by this, as well as everyone else in the community. It's just simply not acceptable. Sorry. I mean, you had a year to do this. No one spoke to us.
Okay.
I'll
I understand
stop
what's
there.
going on. Right, let's take a comfort break at that point. I've not got too much more to get through. If we take 10 minutes now just to have a breather, I hope we'll be done in here by 5. I very much would like to go to the site this evening, if that's okay. Not everybody needs to come necessarily, but I would like to go and conduct the site visit and conclude business, and then we'll wrap up another day. So if we resume at 4 o'clock, then hopefully within the hour we'll be done and on our way. Thank you. Inquiries adjourned. It's 4 o'clock. Let's complete this discussion, please. Okay, Mr. French, question to you, please. In the developed scenario, would there be a reduction in surface water runoff compared to the existing?
Yes, I believe there'd be a reduction, and what I'd say is that nil detriment is not the measure when it comes to sustainable drainage policy. The measure is returning even developed sites back to greenfield runoff, and that's what's not been proven.
If the outfall from the developed site into the pond, which is in Mr. Hallou's land, if that is, I'm not belittling what you've just said about the policy position, if the discharge through that system is going to be reduced, does it matter that the detail beyond the site boundary is potentially a little vague? And I'm not saying it is, I'm just...
We would want evidence of downstream connectivity to a recognisable watercourse in either case, because you can't discharge over land. And we would say an existing situation of discharge over land by flooding should be rectified by a development.
But would this be discharge over land?
If there's no formal infrastructure, for example, between the pond and the watercourse, and the pond simply flooded over land to the watercourse, then the outfall of the drainage system is in part by flooding over land. So at full planning stage, there was on the Springett designs, there was a pipe and head wall shown between the two as a proposal indicating it needed to be installed. So there was less concern at that time. But that's now been removed, possibly because it's in existence and doesn't need to be replaced, but that hasn't been evidenced that we've seen by CCTV survey that there is an existing conduit that's fit for purpose. So we're back to a lack of information.
But even if there is if there's less water than there was going into that pond, whatever happens to it after that, have we not got a betterment?
And this is where, you know, in sustainable drainage policy terms, betterment is not sufficient. There's a hierarchy of methods of disposal to be followed, and none of that involves flooding over land. It should be, firstly, reused, so rainwater harvesting, or as a minimum, things like water butts for residential schemes. And then once that's been maximised, it should be discharged to ground. If that's not possible, it should be discharged to a watercourse. If that's not available, then a surface water sewer or potentially a combined sewer, but not a foul sewer.
Okay, thank you. Is there anything you'd like to say about that concept?
Mr. French, can I just clarify, when you talked about the aspiration is to turn brownfield back to greenfield flow rates, are you talking about brownfield redevelopment with new build development or brownfield change of use? Because I think you're talking about brownfield redevelopment on change of use. That's not the principle to be applied, is it? And I accept our scheme as a mixture, but that's where flexibility comes in. If it's just a change of use scheme, you're not...
Okay, let him answer the question.
So what it applies to is development, which requires planning consent, which affects drainage on or off-site. That's what it applies to. This isn't just a change of use application, and it is major development. So the full suite of standards applies. And there's where we talk about relaxation from standards, this is generally for matters of constrained sites or just a physical inability to achieve those standards. Where you've got plenty of space and plan, plenty of opportunity to achieve those standards, there's no basis for relaxing them just because, or just because the development doesn't have, you know, as much of a new build aspect as another site might.
Thank you. I mean, I think that's fine. We've already discussed that it's flexible. As my colleague is explaining, we meet those standards anyway. It perhaps doesn't lead us to that.
Thank you.
Sorry, can I just add that the connectivity is there, so the pond wouldn't just flood on land. It would drain off to the watercourse.
Okay, yeah, thank you. Is the reduction achieved, the reduction in flow, discharge, achieved because you are building a new system as part of the development?
Yes, so the design's been done on greenfield as per the LFA comments and the standard to take brownfield back to greenfield where viable or practicable. So sometimes there's a minimum betterment that's required for brownfield, but the aim is always to take it to greenfield, and on this design we have.
Thank you.
Can I just clarify the question you asked? When you were asking about discharge being reduced, were you talking about volumes or rates?
Does that make a difference?
So they are separate aspects. I would say peak flow rate is the more important one. Volume is very difficult to reduce without either discharging to ground by infiltration or having sort of genuinely landscape-led integrated suds that has things like trees and other evapotranspiration aspects to it. So on this scheme, it's unlikely that the volume would be reduced.
Do you need it to be?
I don't believe so. No, it's not a requirement in itself.
And your previous answer was about rates then?
Previous answer was about peak flow rates, which is the more critical criteria.
Yeah. Okay. Thank you. Am I correct in understanding that foul and surface water would end up in the same place?
Towards the bottom of the site, the red line, yes, but downstream of the PTP and then beyond there, because obviously it's once they're into the basin/reed beds, they're all together.
Downstream of the PTP?
Yeah, there'd be a connection from the surface and foul to the to the basins or reed beds, and then beyond.
And I think we answered this earlier, but just to make sure I am clear in my mind, you say to the basin and then to the reed beds. Is that the proposal, or is that the revised
That's where
proposal?
the drainage currently goes to. So the combined currently goes into the PTP, which goes to the basin that's existing, that then flows down into the reed beds. But as part of the design, the surface water is being separated from the foul to separate systems and will bypass the PTP and then discharge into that. So in essence, we're removing the surface water from the treatment plant, but then afterwards they'll join back up prior to outfall.
Okay. And even before the 29th of June, was it going from the PTP to the basin
So
to the reed bed,
so
or was it just going straight to the reed bed?
So it currently does that now as part of the existing situation. The original discharge of conditions application had both surface and foul separate systems, but both discharging into the PTP. That's right, isn't it? Yeah. And then one of the LFA comments to that was why.
But the original proposal, section 70, discharge of conditions proposal.
Oh,
The original discharge of conditions proposal, was that going via the basin, or was it
yes,
direct?
yeah, downstream, yeah.
So just for you, can I ask whether the basin is shown on any of the plans?
It's a good question.
It's It's shown in, I think, some photos in, is it the Springer report, which was part of the 21 application.
Because the drawing 1001, which is this one, has got the PTP, and then foul discharge to existing treatment system. So you're saying that existing treatment system is to the basin and then to the reed bed.
Yes, yeah.
But then we've got this blue line that just says discharge to pond.
So that was to bypass the foul treatment system, my apologies.
But that would be discharged to basin and then to pond.
That would be discharged to, I think, the low end of the site.
We'll have a look on site.
Yeah.
It's difficult to know because there's no
survey,
details in this
there's no
white
survey
area,
there,
so I
yeah.
don't know what any of these things are. Would this be a useful plan to have at the site visit? Your path. No, don't worry about it. Is that the path that you own? Hmm. Yeah. Yes. Mm-hmm. Okay. Okay, well, we'll have a look. We'll have a look on the site. I understand. Thank you.
Sorry, I'll put this on. You're describing a separation between the surface water and the foul water going through to the basin and the reed bed. Does that require you to put a second pipe in to take the water separately down to the reed bed, or are there two pipes currently?
So that would require a second pipe, obviously, to because the existing is a single combined pipe with both in. We would need to take the surface and completely remove it.
Okay, well, I'll let you discuss your rights to access out in a different forum. I understand your
And
point.
so there's just one final point of full disclosure.
Yes.
The PTP is shown orientated incorrectly on that plan. It actually runs longitudinally, not horizontally. Yeah, but it's shown orientated 90 degrees to where it actually exists, but you'll see
Okay.
that on site.
Okay.
So I'm so sorry. Can I come back to the flows point? If the appellant is correct that the permission has been implemented, there is no fallback position because it will have implemented the permission which is inconsistent with the prior use. So in my submission, it would be incorrect to treat this as a simple comparison between what could lawfully happen and what this permission is for. Because
You're talking about fallback to the care home.
So exactly, going back to the care home. If the appellant is right, this has been implemented, then under Pilkington principle, the appellant has no right to revert back to the previous consent. So you've heard Mr. French on saying, well, the test is not, increase of rates versus existing versus proposed. It's about greenfield runoff. That's the relevant test. But another reason why it wouldn't be correct simply to look at what sort of this through an existing and proposed lens is because actually as a matter of law, if the permission has been implemented, the appellant cannot return to the care home use.
Okay. That's just been thrown at you. So, if you think that's important, I'll have it in submissions, please, in closing.
Yes, I mean, I'm not going to spend a lot of time on it. If we have implemented, we'll proceed with the scheme, and if we haven't, we'll revert back to the care home. There isn't a scenario that we have implemented and wouldn't proceed with the scheme, so it's irrelevant.
Fine. Okay, that's the end of my questions on drainage matters. Thank you. Yes.
Just at this point, could I just make one very brief point and make a humble request? Could you have a look at the webcast that was done of the original permission of this site? Because in that, the councillors were very clear that they were going to defer it or refuse it because of the drainage issue. The only reason it was passed by the councillors, so it was core to the decision. And it's
This is
on
the
there.
committee meeting you're talking
Yes.
about?
Could I humbly request that you view it and watch it, because it was key that all the councillors, and that's part that goes to the core of the planning system, were going to defer it, refuse it, because this drainage issue with Mr. Lulu's land and the non-usability of it and was known. And so the planning officers said, you need to have a condition there, and that was the only reason it was passed. It would therefore be very odd at this stage now then that, and to be honest, today, it feels like we're in a planning application pre-app in terms of the drainage. not appealing a decision that was made to limit this very specific case. So that condition was made with this knowledge at that time that Mr. Halou had a concern. And so I just would humbly request that you watch the video and have a look at the discussion, because that is how key it was to the decision. So it would be very odd now if that was ignored, because the council has raised it, parish council raised it, the residents have raised it, and the officers have raised it.
Okay, so I hear what you say. I'm not going to watch the recording of the committee meeting. It's not in evidence before this inquiry, but I do hear what you say, and I presume it's a non-controversial point that discussion or something along those lines took place. Mr. Murray? Sorry. So take your point, and it's non-controversial, so thank you. I think that's sufficient.
Well, only, sir, to say that I think myself and Mr. Moore are the only ones in the room that were in that committee room. Even the appellants weren't there. They acquired the site after the grant of planning permission. It is correct that the members of the committee would only grant planning permission with that additional condition. But we aired that this morning in your agenda on the reasons for the granting condition in the first place. So I can say a bit more if you want, but I think we've moved on considerably.
I think I'm happy with the situation, and thank you, Mr. Moore, for clarifying that. So, just looking at some procedural matters about conditions. In the Statement of Common Ground, we've got these conditions 5, 6 and 7. I also have the appellant's suggested versions of them, which do differ slightly, but it strikes me that there's considerable overlap here. And if I were to proceed to grant a planning permission, it strikes me that it can probably all be dealt with within one condition. Is there any reason why that assumption might not be correct? And maintenance. Because it's all referring to the same, it's all interrelated as far as I can tell. And I know that councils like to have condition 7 going to the LFA and condition 8 going to the EA, and it's easy to administer, but in terms of the duplication of what's actually needed to be approved, it's all one thing, isn't it? Ms. Hutton, you made reference to the use of the retrospective condition. I was thinking about that over lunch, and I think Mr. Charles's proposal would be that a new condition would simply have a different trigger. So it wouldn't be requiring things to be done within a certain period of time. It would simply require that no development above slab, for example, took place, which is a fairly understandable concept, I think. So I don't think we're actually in retrospective territory, are we?
So the reason, it really goes to the point I was making earlier about the importance of both surface water and foul water, and not ending up in a situation where you have an indefinite period of time and ultimately the council being forced into approving what would be a substandard design. So what the enforcement type condition would do is give a cut-off date for this all to be bottomed out, and not leave, a very long period of limbo. I'm not going to repeat all of the reasons why these are such important conditions, but it relates to that, really.
Okay.
And if it helps you, sir, we don't think that's necessary. We are going to get on with it. We think we're very close to the end of the journey. We don't think it will take a long time. The only scenario we can envisage if we do go down the enforcement condition route is to still leave the option open for us to appeal if the condition still isn't either dealt with or if it's refused, even after we think we've got to the end of the journey and we think the council's being unreasonable.
And that's built into the standard condition
wording.
wording.
Exactly. So
anyway.
yes, okay, if necessary, but I really don't think it's necessary. We're keen to get on for all sorts of very obvious reasons.
Did you want to say something?
Well, sir, the point of the enforcement architecture to the structure of the condition is that it builds in the ability for an appeal and then the potential for a legal challenge to the appeal. So if we are in that scenario, then I think I would ask you to look very seriously at that. Then in relation to the suggested condition, which is just a new trigger, which says nothing above slab level, I have some reservations about that, and perhaps I'm looking at it too simplistically, but if the slab level is created and you're at oversight level, well, then surely the drainage to each of those new plots would have to have been done, and yet we would be in a trigger for a condition that would allow a scenario where drainage is submitted after that stage. So I don't think it can be above slab level unless we've got some above ground level drainage configuration. Does that make sense?
Yes.
The slab levels are already approved, so there's no suggestion we'd put in a slab at a different height. The approved slabs for all levels.
No, I don't think that's the point. I think the point is that to have got to slab level, you must have had to have laid the drainage.
The drainage isn't under the slabs.
None of it.
Oh, okay. Some foul might.
So the foul connections, so SVPs, soil stacks and the like, would be broken through the slab and taken out, but they could only be taken really as far as an inspection chamber or even just a spur. So that would be part of the plumbing of the site up until sort of first sort of chamber, really.
Okay, well, something to think about.
And the other element we propose, sir, is being able to finish the conversion works in the main building itself, but not occupy it. That's just to give Mr. Here something to do in the meantime. It's obviously costing a lot of money whilst we're all waiting around. And I don't think that's controversial if the building isn't occupied. It has no implications for drainage.
Could those works continue before?
So I'm going to have a think about it. I mean, I come back to my point earlier that when you asked about, because you've got a sort of a building on site where there's going to be a change of use, would you need drainage to be pre-commencement? The law is very clear that when you interpret a planning permission, you interpret it as a whole with the operative parts and all of the conditions as one scheme. Could there be, going to this, so that's one part of the answer. Coming back to, could there be conversion of, effectively a phasing? Could you have a separate phase for converting the building without having drainage of the site? I think the problem with that is that this is one drainage system for the entirety of the site. So my reading of the plans, I don't think any of the plans have proposed one system for the care home and one system for everything else. It's a holistic design. And so it's that holistic design that needs to be worked out and approved.
We weren't proposing occupation of the change of use just to be able to progress the works. There can't be any drainage implications from an empty building, and there's no suggestion the building would be converted differently depending on what the drainage solution is. So I think there's a no risk to the council point.
I think that's something you can leave with me to
Is that
ponder.
something we can leave? So could I just have a think about that? Because that's not been a proposal previously, but we just come back to this concern that it is one system for the
You can,
entirety of the site.
and you can deal with it in closings if you wish.
Yeah.
Okay. I had some questions about some of the other conditions, but your statement of common ground in its final draft has dealt with that So thank you all for that. That's helpful.
Sorry.
Yes.
Just if it helps to have it in a... One of the concerns, it may not relate to surface water drainage, because of course that's falling on the building, coming off, but foul water comes from within the building. And so it's unclear whether there would need to be, presumably there would need to be approval of details relating to the property itself, because foul water comes from within the...
But it'll have to come out the same place,
It will have
won't
to
it?
come out, yes, come out the same place, but the foul water is internal to the building.
But whatever
itself.
works that happen inside the building, surely it's always going to come out of the same place. And
well-
then it require an onward connection.
Well, is that right? I don't know. Would it always come out of the same place? I don't know.
Do you have a thought on that?
Yeah, if we've got approved floor plans, you'll have the connections, and the usual is to take them out of the building at a typical point, which is quite often the closest outside wall. So if we took that, and I'd be happy to run that by the LFA at an early stage, but they would, because of the levels and the fact the site falls, we're not going to be running at the extreme limits of design. We're not going to be running pipes as absolutely flat as we have to, or as we can do under building regs and the code. We can allow quite a bit of slack in the system.
So I think the short point is that is one detail that would need to be approved. So that's really the exit point would need to be approved.
Okay,
Could I please ask 2 questions?
you can. So the next thing on my agenda is whether is there anything else that anybody wants to say? So, Mr. Davies, of course you can.
Thank you. The first is, for my understanding, if you were minded to agree with the appellant and to allow the planning, there are aspects that we've heard today. The 2 pipes are one example, which in the view of myself and my fellow residents, we think are definitively against the legal agreements in terms of what they permit. It's not a matter for planners, I understand that. But if, on that basis, the development were to go ahead in the sense of aspects being built, we successfully challenged the ability of the development to drain, so it wasn't able to. A court agreed with our position that there isn't a right. As a resident, I'm concerned that we will be left with a development built, unable to be occupied, and with the local planners unable to require it to be removed. So it would sit there as a white elephant and a major problem. Is there a planning legal route to address this, or am I correctly describing something that potentially could happen if you were to reach that decision?
Sutton, would you like to answer that question?
There is a risk of that. So either that is one risk, is that you get, yes, a converted care home unable to be occupied, or, as my earlier submission, the greater fear is that the appellant would then say, well, you've got to improve these designs because, notwithstanding the fact they don't meet relevant standards, you can't interrupt the principle of the permission, and therefore you have got to approve this. So that is another but separate concern.
Mr. Charles, your take?
Yes, so zero risk in reality of happening if they were to bring a claim, they would have to establish that the loss they had suffered, if there were a breach, was not compensatable with money, which I don't think they would be able to do. And if they were able to ascertain it was compensatable by money, then they'd be paid the money and the development would proceed. If Mr. Here didn't pay the money, his company would become insolvent, somebody else will buy it and pay the money, and it'll carry on. So there's no scenario that it wouldn't ever happen. The amount of money that you would be due would never be more than was possible to be paid, because that would be the calculation of what the loss was. So I've said that quite quickly. I'll say it again. They would injunct to say you couldn't do the work. If they were successful, they would have to prove that the loss they had suffered wasn't compensatable with money. If it's compensatable with money, the money would be paid. If it's not compensatable with, well, and that's the point, I don't think they'd be able to show there was no loss that couldn't be compensated with money, and that would be the judge's position.
Okay.
And so it's never going to be left stuck. It would get resolved by the courts. But we don't think there's any basis for even
I know you
a
don't.
claim, and even if there was compensatable with money, it would be a token sum, because there isn't really any loss, because there's an improvement arising from the scheme, not a detriment. They couldn't claim for the impact of the new build houses. It would be the impact of a drainage scheme that reduced both the amount of foul and the flow rate of the surface water, which obviously would be nothing.
I understand your point. Thank you. Mr. Moore?
Hi, thank you. I must admit, my point's slightly different really here, in the fact that we know this problem exists now as we knew it existed on the day that planning was granted. In that period, the appellant hasn't spoken to Mr. Halou to either discuss, arrange, or sort out this drainage issue, which has been front and centre since the decision was made. That is crazy. They're complaining about not being held up with their plans and everything else. They've not spoken to Condition 8 at all. And I have to say that after watching the sort of councillors talk about it, the officers talk about it, this is a greenfield site. It was built outside of the development boundary. It was built in a field, and it was given special dispensation because of a building that was existing there that was meant to have been removed, but then it was given. We know this problem is here. We shouldn't really be talking about court cases that will come from this decision when we have a solution in front of us. That is putting far too much pressure on a resident when we know the situation. We know the EA has spelled it out. It needs a bigger bit of drainage works that there is a disagreement about. Before anything should have happened, before this planning permission should have been given, in my view, that should have been threshed out. The system did try and do that. They said Condition 8. The appellant has chosen not to resolve it. And then they're appealing the fact that they've chosen not to resolve it. This kind of brings the planning system into disrepute, because we see conditions issued all the time, and residents go, okay, well, is this condition, does it mean anything when this condition is given? Because that is why, this is how this application was justified to the community. And it is worrying that the EA are saying you need to do this, this, and this. And when we're talking about flow rates and this and that and the other, we're talking about 9 extra houses with potentially 30 plus people, with big roof spaces and with 30 plus bottoms. Are we seriously saying that's less foul drainage? I just don't believe it. I'm sorry.
I'm not going to go around that point again, but yes, thank you.
You understand what I'm saying? I mean,
Yep.
To the public are not going to understand that.
I understand your...
So what I would ask is, can we not, there is a mechanism for doing this. The mechanism was in Condition 8. The fact that they've chosen not to resolve it, well, you make a new application, don't you?
I understand. Mr. Charles, would you like to respond?
Just to say that the planning system can't grant a ransom to Mr. Halou that he doesn't have at the moment. The condition required demonstration of an agreement, which has been demonstrated. There's an agreement in place. There's no requirement for a new agreement. We're not doing any works on Mr. Halou's land. I'm sorry, that's the position. We can't go and talk to somebody about something we haven't got anything to talk about.
You may in just a moment. Yeah. Yeah.
Please.
So as I say, the 8 permit issues are not before you, sir, and the land ownership issues, if there were any, are not before you. I understand members' heads were turned, but that's not relevant to today's proceedings.
I just heard another inconsistent statement that nothing is going to be constructed on my land. Yet, maybe 20 minutes ago, we heard that there would need to be a new pipe built under my land to separate the foul waste from the other water. So, I mean, sorry, we're sitting here a year after a very clear condition was established as a Grampian condition. In the video, I did listen in on Teams to that council meeting. It was extremely clear. And the council made this a major condition to giving this application consideration. There has been zero effort to resolve this. There's been zero effort to get me comfortable. I've raised objections in writing multiple times. I have submitted statements. They've been consistent. I'm still hearing inconsistencies today. This is not a laughing matter. This goes to environment in an AONB. I mean, many of us live in the area because it's a beautiful area which is clean and protected and safe. This is simply not good enough. I'll say it again, but that condition was there for a reason. It has not been met. The application has lapsed. We need to move on. We all want to see this site developed. We want to see a sustainable, deliverable development. We've been saying that for years. And in the meantime, I've got 3 kids living next door. We've had squatters, we've had crime, we've had drug dealers, we've had all sorts of issues on site for over 4 or 5 years. This needs to get resolved. We can't just keep kicking this can down the road, pretending that if we sit here and talk about flow rates and don't respond to technical requirements that were requested by the council, that we're all going to be okay at the end of the day. We're not. So I kindly request that, we look at the appeal against the original application and the conditions that were put in place very clearly, with a very clear intent. And I think it's that simple. It has not been met. There's been no effort to meet the conditions, so we need to move on.
Thank you, Mr. Helou.
If I could, I think it says clearly, no development approved by this permission shall be commenced until full details of proposed means of foul drainage disposal have been submitted to and approved in writing by the local planning authority. That still hasn't happened, and we're at an appeal of this condition.
Yes.
The approved drainage work shall be completed prior to the completion or occupation of any dwelling on site, whichever is the sooner. The details shall include evidence demonstrating an agreement in place to allow an output.
Mr. Moore, I know what the condition says.
Yes, I know, but what's confusing me and what's slightly irritating me, I have to be honest, is the appellant's counsel keeps on saying they don't need to talk to anybody about it. It's condition 8. That is the condition we're talking about appealing. That is it.
I understand. I understand. Thank you. Mr. Davis, you had 2 points you wanted to make, and you made one of them.
Well remembered, thank you. The second goes back to a comment you made at the very start of today, which is that if you were to allow the appellant's case to go forward, it would constitute a new planning application, a new approval. Things have changed since the previous planning application was approved, and in the interim, one of the changes has been the introduction of the biodiversity net gain concept. I haven't seen anything to address BNG in any of the papers, and maybe I just haven't noticed it, but would BNG apply were you minded to support their application?
I think I'm correct in saying no, because it's made under Section 73 of the Planning Act to grant permission without complying with conditions on an existing permission. So there's a specific route that this is following, and it's BNG exempt. That is right, isn't it?
Absolutely correct, sir.
Yeah.
So yeah, I can double check that.
I don't normally like to make such
yeah,
pronouncements, but I believe that's right.
So just on the overarching condition point, is it all right, because obviously we've seen this just today, we would have comments about what this is requiring, Mr. French says it should actually be requiring what the original conditions required, for example. So all of the requirements of condition 8, etc. So I wonder if we just address you on that in closings, because we're going to have to go and draft a potential condition.
So basically, the list of, are you saying that the list of requirements that's in conditions 6 and 8 should be transposed into this overarching condition?
Yes.
I say, do we need a list of requirements when you can say, I'm not approving that because this is missing? Because when I like to draft conditions, I like them to be nice and short.
Yeah,
Councils like them to be very long.
Well, I suppose so. It's about clarity about what's required. A lot of the discussion today has been about exactly that issue. We say it's absolutely clear on the face of the condition, condition 6, what is required. And the suggestion from Mr. French as well. So we've given our view on whether you could, it's right, you could just carry out the conversion works of the care home. I've addressed you on that. We say there's still a concern about that. Mr. French also suggested, so it says no new build above slab level or change in external levels or external paving should also be included. And then we would, yes, or continued conversion works to the care home. But perhaps if I put that into closings in writing, that might be helpful.
Yes. Do you?
I'm somewhat
Ms. Hutton's
torn, sir.
proposed-
I like your short and broad approach, because that is, of
You
course,
like it,
absolutely
but do you
correct.
have a problem with the
But,
council's proposal?
we just want normal service to resume and the silly guessing games to stop. So if we're told what we need to do, we're very happy to do anything within reason. A bit of my opening I didn't get to is, we're very happy to talk to anybody and accommodate all technical requirements. We don't want another condition saying we have to demonstrate agreement that we've already demonstrated, so we don't want that element. But we're extremely open on the technical front to solve all issues, because we are utterly confident there are solutions to them available, and so we're happy for that to be broad. It doesn't need to specify a new outfall anywhere, it's just whatever actually is needed for the scheme.
Okay. Right. That's the end of sort of general discussion, as far as I'm concerned. If everybody's happy. So just a little bit of housekeeping then on what's going to happen next. We will head over to the site. 40 minutes-ish, is it? About that. And we'll have a look. Mr. Hillo, if you could arrange for me to see the pond, the watercourse, etc., and we'll see the site of the basin. Okay, well, I'll let you agree amongst yourselves that we're where we think we are on that, and then you can clarify to me. In terms of a useful plan to have at the site, obviously now currently have a hard copy of this one, but I think this 1001 drawing is potentially useful. Is there a drawing, does the location plan have the pond on it as well? There's nothing particularly helpful. We'll deal with 1001, and I think that's the way forward, really. Where will we meet? Oh, on the site? Okay. Okay, well, but it's not. Yeah, we'll meet at the car park on the site, shall we? So who? To the front of the care home. And we can walk from there through the site? Okay. So who am I expecting to see at the site? All of you? And all of you? One, two.
So I was really hoping that Mr. French would be able to go, but he's got a hard cut-off. So I don't know whether it's possible to go to the first part of the visit.
Realistically, at 6:30 from Uckfield.
You need to get back to Uckfield for 6:30, did you say? You need to leave Uckfield at 6:30. So where are we now? So you're going to struggle to go at all. Okay. I mean, I'm going to have a look. I'm not going to have a discussion. So I don't know that you need to be there on this occasion.
You know, I would say from an LFA perspective, site visits aren't the answer. But we don't deal in site visits. You know, whether it's clear on site or not, there should be plans and surveys and.
I mean, if for some reason, you know, I need to make a decision on this appeal. I need to see the site. I don't need to be accompanied by everybody. But if for some reason in the future you need to see the site, then you can. So,
Mr. Robbins and Mr. Carey from the council.
Mr. Robbins and Mr. Carey. Fine. Okay. Okay. I suspect if it's going to take us 40 minutes or so to get there, by the time we've packed up, it's going to be quite a late one, I'm afraid. I'm sorry about that. But so we will we'll do we'll say 5:45 at the site, please. After that, the inquiry will adjourn. No, the inquiry is going to adjourn now, the site visit. Sorry, as a standalone procedure, I was in hearings procedure for a moment. It's an inquiry. So I'm going to adjourn the inquiry now, and I'm going to conduct the site visit on a basis of just going to look. And then we need to hear closing submissions. Ms. Hutton, are you available on Thursday?
Yes, sir.
You are. And you're available on Thursday. So we'll do that virtually then via Teams. So if somebody from the council can send through the link, and then of course anybody can join. But that's a formal process. So what happens at inquiry closings is that the council is going to deliver their closing statement, and we'll have a short 10-minute break or so, and then the appellant will deliver their closing statements, and that will be the end of business. And costs. So costs, how long do you think you'll be in closings?
In closings, probably, I can whittle it down, given we've removed the drainage basin, etc. Up to an hour.
How long do you think you'll be? Do you have a preference of hearing costs orally, or just do the whole process in writing?
I think I'm happy with the whole process in writing. So.
I'm happy to do that. So what we'll do is we'll have a compressed timetable. So if you can make sure could I have costs applications by Friday? Say Friday midday. Then we'll cross-copy. And if we could have costs response by close of business Monday. And then we'll cross-copy, and if we can have final comments, close of business Tuesday.
Tuesday.
just to be clear, just so there's no ambiguity in the room, that means there's no teams on Thursday. So it'll all be done in writing, yeah?
No, closings, inquiry closings will have orally.
Okay.
Via Teams. And after and then I'll close the inquiry, and then we'll deal with costs in writing. And because there's 2 applications, so we'll just simply twin track them. Application, response, final comments. And then we can issue the decision thereafter. Okay, thank you everybody for your contributions today. I'm sorry it's been quite a long day, but I think I've understood a few things that I didn't before. So thank you all for your contributions to the event, and I will see you at the site at 5:45. If anybody's missing, we'll just wait for them to arrive. Thank you. The inquiry is adjourned.
See you later. Only 3 of them could make it. Just grab their emails outside of the guys that were sitting there. Yeah. So we've got them to invite them for the first day. Right, yeah. Teams meeting. You got their emails? Brilliant. Do you need the hard printout copies of the copies? Good to see you. Yeah. See you later, guys. Bye-bye. What's away? Yeah. What's happened? Is it like an inquiry or is that?
No, it's just a minor planning committee. So we've got mine is an immense planning committee as one of mine.
Oh, that, yeah, of course I did the list for it.
Yeah, that's it. He probably added my one onto the list.
Was that mine?
Yeah. I mean, my car broke down once in the car park and I left it in there overnight.
So end.
I went into Tesco and said,